la tía Marta me dijo que quiere que le para me dijo que sí, ya no podía ver. Y ya desde
Good afternoon, courtroom 80.
Good afternoon.
Yes, I saw that you guys tried to call.
Yeah, we have two at South County that's needing a Creole.
Two that need Creole. What are their last names?
Pierre
Okay,
and Bleeker, Plear, Pleakir.
P with a P or a B.
P as in Paul.
Okay. All right. Thanks. No. Any Spanish in South?
We got 11 of them from Central.
Okay. Thanks. Bye.
11.
All right, good afternoon, everybody. Judge Stamey here at the Polk County Courthouse. I can see the folks from South County and everybody from Central. I even see the juvenile here at the courthouse. If y'all don't mind, you don't have to stand up, but just where you are, raise your right hand to be sworn in. All right, everybody, raise your right hand. All right, do you swear or affirm to tell the truth, the whole truth, nothing but the truth? If you agree, say I do.
I do.
Great. Everybody that just said I do, put your hand down. If you didn't say I do, raise it up real high. All right, no hands real high, so everybody's sworn in. Ms. Cadenas, I'm going to read the advisory and, well, you guys have a couple quick ones. I can get you guys out of here before. Yeah, let's do that. If you don't mind, Ms. Cadenas, hold tight. I'm going to do the private attorneys to get them moving on, and then we'll do the Spanish advisory and the English advisory. Who wants to go first?
Good afternoon, Your Honor. Christine Vasquez for Jacqueline Green. For Frey and Hagasalt.
Good afternoon, Ms. Green. You're right. It's a fray and aggravated assault. You'll be representing her on this?
Yes, Your Honor.
Okay. Ms. Green, there's for you and other folks that are listening, there's 4 things I do. The first thing is we tell you what you're charged with. We just did. It's an affray, misdemeanor, and aggravated assault. Then I determine whether or not you want me to appoint a public defender or if you have a private attorney. We've done that. The third thing is probable cause. Any challenges to probable cause from the affidavit?
Not at this time, Your Honor.
Sure. So I did read it. I have a big old stack of affidavits that I've read back in my office. It took me about 2 hours. So I've read them and I got them in alphabetical order. So I'm going to find yours.
Your Honor, if I may,
Sure.
on the affray charge, I would argue that there's no indication on the police report that she agreed to fight anyone, which is a required element of the charge. all the officer indicated was that there was a fight and he has absolutely no idea who started it.
Yeah, it says they engaged in a physical altercation on a public roadway in front of a school bus. They got into a physical fight.
Right, upon
They didn't call it
admission.
battery. So I mean, battery, when two people want to fight, well, we call it a boxing match. If it's in a ring or if it's in public, it's an affray. Two people, it's free country. Two people can fight if they want to. You just can't do it like in a public place where people see it and they're outraged or offended by it. So here they didn't call it a battery. So they're not alleging she struck the other woman or the other woman struck her. They both agreed to fight. That's how I read it. But you think you read it differently?
But the agreement part is where I would contest that.
Yeah, well, it certainly appears to me that, whether they use the word they agreed, it certainly implied here that they engaged in a mutual physical fight. What's the state say about that? Do you have any response to the argument that it's not PC for an affray?
Kenny later on, he took my argument, based on the explanation. But just reiterate, state would argue that kind of based upon the actions between, defendant, and I guess the other defendant in this case, Your Honor, I think there's enough here to find probable cause for restraint.
Yeah, like I say, it's a free country. If people want to duke it out, we'll just do it in private or do it in a boxing ring or somewhere like that, and people are allowed to fight. Someone can't walk up to someone and one side wanting to fight and punch the other person. That's for battery. So here, when it says that you engaged in a physical fight, I do think for today's purposes, which is first appearance, not your trial. What's needed to win at trial is way up here. What's needed for first appearance is a much lower threshold. So I do believe there's enough here in this affidavit to support an affray and for ag assault. You want to be heard as it relates to bonds?
Your Honor, I would ask for a reasonable bond. She's never been in trouble in her life. 3 kids, been at the same residence over 7 years. And was not the initial aggressor.
Ms. Green, I'm going to set let me look real quick. And you haven't been recommended for straight pretrial release. And as far as the record, you agree, you don't show anything from Ms. Green.
We can ROR on the affray and then reasonable bond on the ag assault.
Well, I don't know. She's not been recommended for straight pretrial, which is even higher than an affray. I will give her some, I'll tell you what, I'll reduce the bond on the affray to $500. Our standard bond for an aggravated assault is $5,000. You have no record at all. I tell you what, I'll reduce that as well because of that. I'll do $2,500, $3,000 total. I'm going to make it a condition of pretrial release. If you post bond, you must immediately check in with the Office of Pretrial Services. That's here in Bartow. If you get out today, if you bond out, you're probably not going to make it there today. You have to do it the very next business day. Sign up here in Bartow, show up in Bartow in person, sign up in person. Call them with this charge. I think it's fair to have you call Tuesdays and Thursdays. So every week on Tuesdays and Thursdays, call into the number they give you. While on pretrial release, you have all the standard conditions that everybody else has. But based upon this charge, I'm going to give you the special conditions that while on pretrial, you are not allowed to have any intentional contact with the alleged victim. This means directly, indirectly, or through a third party. You must stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. You also, while on pretrial, cannot be in possession of any weapons, firearms, ammunition, or knives, okay? If you're otherwise legally able to have those, while on pretrial, you have to get rid of those things. No weapons, firearms, or ammunition. Otherwise, you could get yourself into trouble. Anything else?
No, it was nice to meet you.
You too, you too. Take care. Have a nice day, folks. Just great. Ma'am,
You talk.
Madam Clerk was, I think, has something. Raza, who would you like to call?
You actually signed the arrest warrant and there's bond already on it.
Mr. Johnson. Yes, so let's do that. Just call Charles Johnson. Mr. Johnson, you are charged with violating your probation. Ms. Praz is right. I'm the judge that signed it. You're representing him on the BOP.
Yes, Your Honor.
So told you what you're charged with. You have an attorney. I find probable cause because I signed this 2 days ago. In your situation, I didn't believe no bond was appropriate, so I gave you a bond of $2,500. If you bond out, just know that you have a hearing in front of me on
I think the 21st, yes, Your Honor, 21st
Yeah.
at 8:30 a.m.
May 21st. So I would certainly encourage you. Say again?
The new date would be June 1st, because this was with, the first date was,
On the street
date.
Yeah.
Oh, you switched it on me?
So I would certainly encourage you to, if your color comes up between now and the 20th, please make sure you go provide your sample. And I would certainly hope that the list of things that they're alleging that you violated your probation shrinks as opposed to gets longer. Okay, have a great day, sir. We'll see you on the 20th.
Thank you, Judge.
Oh, this way, sir. Hey, fellas, can somebody at the phone?
Hi, who'd you like to call up?
Hi, Your Honor. Melissa Flores. I have Mr. Leonard Cologne.
Is Mr. Cologne a interpreter case? It doesn't look like he is.
No, sir. So I have the arrest warrant. It was also signed by you a few days ago. And the only issue is, well, that I would like to talk about is the no bond. I do know that you signed that, and I also received a notice to appear. So I was wondering if maybe we could get a reasonable bond for him so he could go ahead and finish those conditions of his probation. That'd be wonderful.
Any idea why he's so far behind on doing his conditions of probation? To your point, yeah, I did choose, unlike the last person, I chose to do a no bond on this one. Because candidly, the list was just so long and it doesn't look like he did much of anything. And the part that really was the kicker was he failed to show up to see his probation officer in April.
Yeah.
I'm fond of saying, if you're on probation, it's hard to do it successfully when you just don't go see your probation officer. So any idea at all why?
Yes, Your Honor. I did speak to his wife, and she did inform me that he's had some mental issues in the past few months. The day that he was supposed to see his probation officer, he was hyperactive. And then he was put in a rehab facility. He has been doing steps to getting better and getting some medication. She did inform me he has an appointment next month with Peace Rivers. So he's on the mends and would love to be able to get out to go ahead and get that sorted out.
So you believe, and I know you probably didn't get a chance to verify, but you believe that he was Baker acted at the time he failed to appear to see his probation officer?
Yes, Your Honor.
Okay. If you take that one thing out of the equation, then all those other things he could come into compliance. Anything from the state, I'm kind of convinced, candidly, that was the one thing that probably led me to believe, or led me to sign the no bond when you don't go see your probation officer.
At this time, Your Honor, state will be requesting that you be held no bond. It's a good issue. Sure.
Well, he's coming to see me. Yeah, he's coming to see me. And that date, it says M6 526. How can that one be 526?
Tuesday. Holiday on Monday.
Yeah. Well, the last one was with me and it was on 520. So I put it in front of somebody else.
Last one?
Yeah.
That was with Lakeland. So we reset it to Lakeland because he was having on.
He's a BOP though.
Yes, so because.
How do we know he's going to bond out? What if he doesn't bond?
We don't, so we requested for a jail date.
Right, but I'm the one that signed the warrant, so should it not come to me? Yeah, it was my division, but these last two cases are,
He originally set it with M5. So, yeah.
Hey, y'all got old thing.
we did this.
no, I mean, typically, yeah, that's what I'm saying. So, and I signed the warrants that are assigned to me, so that's where I
That's
didn't,
where it was set.
yeah,
We set it with us.
okay, fair enough. So, I'm convinced. So do me a favor, if you plan on being there on the date, 526 is the date we're giving him. I would love, not that I don't trust you, but like I said, I don't believe you probably had a chance to verify. If there's any documentation that he was, had been Baker acted. That would not be a bad thing to bring. Just say, hey, Judge, I told you, now here's the proof
Of course.
that he was Baker acted when he should have been there. Okay, sir, I'm gonna find probable cause. I'm gonna set your bond. What's good for the goose is good for the gander. I'll set it at $100. All right, so sir, if you bond out, right now you have 4 things on your list that the probation officer said that you've done wrong. One of them we talked about, the other 3, you can come into compliance. I would strongly suggest that this list and the things they're saying you did wrong shrink and not grow between now and when I see you again, okay? Have a great day, sir.
Step to your left.
Thank
Yo.
you.
Yeah. See you again.
You can see.
All right, we have a couple other attorneys. I see we have a Creole interpreter. Mr. Alvarez, hold tight, please. I'm gonna get our Creole interpreter out of here. Let's call up Ernst Pierre.
Est-ce que nous pouvons parler avec Monsieur Ernst Pierre?
Mr. Pierre, you're charged with resisting an officer without violence in violation of injunction for protection against domestic violence.
Donc, Monsieur Pierre, ou gen 2 accusations contre vous, que vous avez résisté yon officier en la police sans violence et ou te violé en condition pour yon te mette contre yon interdiction dans yon violence domestique.
Sir, do you want me to appoint the public defender to represent you?
Monsieur, est-ce que vous avez aimé joindre un défenseur public, yon avocat public pour représenter vous?
Yes, Your Honor.
Yes, Your Honor.
I'll do just that. I've looked over your affidavit and I find probable cause for the 2 charges.
Moi gade document yo, affidavit lan, et moi que gen bon jan raison pour accusation sa yo.
I'll set your bond at $1,000 cash or surety on each case, each charge.
M'a mande pour yo lag yo, c'est $1000 caution. Donc sous chaque nan accusation yo, $1000 sous chaque violation.
Going to make those bonds conditions of pretrial release.
Donc si vous postez comme ça, postez bon sa yo, ap gen condition yo imposé ou pour yo lag yo.
If you post that bond, you must immediately check in with pretrial services.
Donc kou postez bon sa ou bay comme ça, faut kou aller dans service avant jugement, ça yo les pre-trial lan.
Sign up in person and call them on Thursdays.
Yeah.
Faut kou
J'aimerais
inscrit
personne
ensemble
en
avec yo en
compagnie.
personne. Faut kou inscrit ensemble avec yo en personne.
D'accord.
You have all the standard conditions plus special conditions, 16, 17, and 19.
Wap gen tout condition normal yo, et wap gen ajouté sous condition sa yo 16, 17 et 19.
You're not allowed to have any weapons or firearms while on pretrial.
Ou pa gen dwa gen aucun zam nan posisyon tout pendant que yo lage yo avant jugement.
You can have no intentional contact with a listed victim,
Ou pa gen dwa kontakte victime nan dosye sa pièce.
and you must follow all the terms of any injunction that are currently in effect.
Donc si yo gen aucun bagay yo interdit ou pou fè, faut kou suive l'ordre sa yo.
Have a nice day.
Passez un bon journée, monsieur.
Takiri Odom.
I believe that's all for Haitian Creole, Your Honor.
Oh, I
one
had
more.
I'm sorry, I
One more?
apologize. I had one more, Jaden Plesker? How do you pronounce it?
P-L-E-K-I-R.
Pleaker. Yep, Jaden Pleaker.
Okay.
Sir, you're
Donc,
charged with trespass.
Donc, Monsieur Jaden Plecker, donc, accusation yo gen kontou, c'est ou te traversé un côté ou pat gen droit aller.
Non, e pa vwe, c'était un parc li bagay aucun ba trespass la dan, c'est non parc mwen te kouche, son ban mwen tap dormi.
So no, that's not true. It was a park. They didn't have a no trespassing sign. I was just sleeping.
Sir, do you want me to appoint the public defender to represent you?
Monsieur, est-ce que vous avez un défenseur public, un avocat public pour représenter vous?
Oui, s'il vous plaît, parce que m'da men sa.
Yes, I would like that.
I'll appoint that office.
eh bien, m'a tout assigné yo pour représenter ou.
I reviewed the paperwork and I find probable cause for the charge.
Donc, moi, ouais, que gen bon jan raison pour accusation sa yo.
I'll set your bond at $1,000.
Et pour bon ça,
Dis,
pour yo lage yo, c'est $1,000.
Di kon sa ke se yon mles mwen bagay oken moun, mwen bagay se nan la rim dormi.
So I'm homeless. I sleep on the street, so I don't have any means.
All right, sir. Have a great rest of your day.
Okay, passe une bonne journée, monsieur.
Step to your left. This one.
All right, Mr. Georges, thank you so much for helping us.
All right, thank you, Your Honor. Have a great day.
You do the same. All right, hold tight, Ms. Godinez. Mr. Alvarez, go right ahead.
Judge, if we could let Ms. Godinez do her speech, minus that interpreter case in Spanish.
All right, Mr. Kaler, do you have a quick one that we can do before I get into the speeches?
I do, Your Honor. Thank you for calling my case. I'm supposed to be in Lakeland Court right now. Judge, I have State of Florida versus Damari Jones, CF 24-01675. Judge, do you have it on the docket today?
I have a Darian Jamon Jones. It's spelled Dearian Jones.
Well, Judge, the one I have is, let's see here. What case number do you have, Your Honor?
The one that I just read to you is a 26 MM2339.
No, Your Honor, that's not the one I have. I was told that we had a first appearance on the Damari Jones. You do not have a Damari Jones on the court's calendar
Not
today,
on
Your
my
Honor?
list, but I can check with our clerk, Ms. Dawes, or it doesn't look like we do, Mr. Kaler, but hold tight, we'll confirm.
Judge, my secretary just sent me a text saying it got changed till tomorrow. So there we go.
There you go. Mystery
Thank you for your-
solved.
Yes, Your Honor. Thank you for your time. You have a good day.
You too. All right, Ms. Godinez, if I read this advisory in English, would you please read it in Spanish?
Yes, Your Honor.
All right. Good afternoon, everybody. Judge Stamey here at the Bartow Courthouse. This is your first appearance hearing. A first appearance hearing has four purposes and four purposes only. First, I will advise you of the charge or charges that have been filed against you. Second, I will ask if you have an attorney representing you. If you have hired an attorney and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward today with your hearing or postponing the hearing until tomorrow. If you postpone the hearing until tomorrow, it is your responsibility to contact your attorney to let them know you will have court tomorrow. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, and if you wish to have one appointed, I will ask if you can afford one. Well, that's what I'll do first. I'll ask you, can you afford one? If you tell me that you can't, well, let me read that again. If you do not have an attorney, I will ask if you can afford one. If you can afford to hire an attorney, so be it. We'll make a note of that and move on. If you cannot afford one, and if you qualify, I can provisionally appoint the Office of the Public Defender to represent you. That, of course, is you'll have to, at some point, fill out a formal application. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those challenges. And finally, I will review your bond or other conditions of release with you to determine if any changes are needed. Please be aware, if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. For example, if you are told to have no contact with a certain person, such as the victim, and you call that person from the jail before you are released, you are in violation of your pretrial conditions. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located at the jail, as well as where you are located, where I'm located at the courthouse, as well as where you are located at the jail, is being recorded. There is an assistant state attorney present listening to everything that is being said, so do not say anything about the crime itself. Please keep these rights in mind as we go through this process. Please step forward as your name is called.
Buenas tardes, esta es su primera comparecencia. La audiencia de primera comparecencia tiene solo 4 propósitos. Primero, le informaré sobre el cargo o los cargos que se han presentado en su contra. Segundo, le preguntaré si ya le está representando un abogado. Si ya usted ha contratado abogado y éste se encuentra presente, entonces será el abogado quien hable en representación suya. Si su abogado no se encuentra presente, usted tendrá la opción de proceder con su audiencia hoy o posponerla hasta mañana. Si usted decide posponerla, será su responsabilidad contactar a su abogado para hacerle saber que tendrá una audiencia. Nadie más hará esto por usted. Si usted desea proceder sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si puede pagar por uno. Si usted puede, tomaremos nota de esto y procederemos. Si no puede y califica, el juez asignará provisionalmente la oficina del abogado de oficio para que le represente en espera de que usted llene una solicitud para estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán de inmediato. Finalmente, estaré revisando sus fianzas y otras condiciones de liberación con usted para determinar si es necesaria cualquier modificación. Debe saber que si el juez lo pone hoy bajo libertad condicional, independientemente de si es directamente o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia estarán en efecto de inmediato, aunque usted aún se encuentre encarcelado. Por ejemplo, si se le ordena no tener contacto con cierta persona y usted llama a esa persona desde la cárcel antes de salir en libertad, usted estaría violando su libertad condicional. Durante todo este proceso tiene usted el derecho constitucional de permanecer en silencio. Si decide no permanecer en silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde yo me encuentro, así como también donde usted se encuentra, está siendo grabado. Hay un abogado de la fiscalía presente escuchando todo lo que se dice. Así que no diga usted nada sobre el delito en sí. Por favor, tenga presente estos derechos durante el transcurso de este procedimiento. Favor de pasar al frente cuando llamen su nombre.
Hold tight, Ms. Godinez. Let's call our juvenile, Anthony Parton. Mr. Parton, you're charged with 2 violations of your probation. 2 charges that you're on probation for, burglary and grand theft. You want me to appoint the public defender?
Yes, sir.
I'll appoint that office. I've looked over this warrant I'm holding here from Judge Harb. From this, I find probable cause. He specifically wants you held no bond. We'll hold you no bond and you'll go see him on May the 26th. Have a great day, sir. All right, Mr. Alvarez, tell me here who you want to call up.
Judge, if we may call State B. Carlos Gomez Perez, 24 CF 6844. Judge, this is also a violation of probation and it's a no bond warrant from Judge Harb. So if we could have the earliest possible arraignment date.
All right, Mr. Carlos Gomez Perez, you are here for a VOP. What put you on probation was domestic battery.
And it is an interpreter case. I apologize, Ms. Godinez.
Ms. Godinez, yeah, you're muted. If you don't mind, unmute, and I can repeat myself if you'd like.
I am present now, Your Honor. I forgot to unmute.
I understand. Okay. I understand. Let's do it all from the beginning. Let's call up Carlos Gomez Perez.
Carlos Gomez Perez.
Sir, you're charged with...
Sorry. Go ahead, Judge.
You're charged with violating your probation on a charge of domestic battery.
Señor Gómez Pérez, ¿está usted aquí por incumplimiento de su libertad probatoria por un cargo original de violencia intrafamiliar?
Mr. Alvarez?
Yes, sir. Good afternoon, Judge. Ricardo Alvarez on his behalf. Judge, he was arrested on a warrant, no bond warrant from Judge Harb. I'm just asking the court to set it for the earliest possible arraignment.
Buenas tardes, señoría. Este es el abogado Ricardo Álvarez a favor de él. Él fue arrestado según una orden de aprehensión emitida por el juez Harp. Lo que estoy pidiéndole es que le dé la fecha más rápida posible para la lectura de ese cargo.
Sir, I'm looking at Judge Harb's warrant and I find probable cause.
Después de repasar la orden de aprehensión del juez Harp, encuentro motivo fundado.
Judge Harb wanted you to be held no bond.
El juez Harp quiere que quede detenido sin fianza.
Mr. Alvarez, the date that the clerks have given is May the 26th. Does that satisfy you?
Señor Álvarez, la fecha que la señorita escribana me ha dado es del 26 de mayo. ¿Eso es satisfactorio?
Judge, if there's an earlier date, I would take it. If not, then that would satisfy it.
Señoría, si hubiera una fecha más cercana.
Mr. Alvarez, I tried, our clerks are telling me they have to have at least 3 weeks and that's just barely over.
Yes, sir.
Señor Álvarez, lo he intentado, pero las señoritas escribanas me dice que necesitan por lo menos 3 semanas y esto es un poquito más de 3 semanas.
Mr. Alvarez, your client has a hold for ICE. So I'm going to ask the clerks to prepare a detainer. Just wanted you to know.
Señor Álvarez, quiero que sepa usted que su cliente tiene una orden de retención para ICE y voy a pedirles que me preparen el documento.
Thank you for informing me, Judge.
Gracias
No
por informármelo.
Have a nice
Yes,
day,
I'll
gentlemen.
Que tenga buen
Thank
día.
you. Thank you, Judge.
Welcome. All right. Let's move down the list of Spanish. How about Gretchen Estacio?
Gretchen Estacio.
Ma'am, you have a warrant from Osceola County for failing to appear for court.
Señora Estacio, tiene una orden de aprehensión del condado de Osceola por incomparecer al tribunal.
I cannot appoint a public defender in Polk County for an Osceola County charge.
Y yo no puedo asignarle un abogado de oficio por un caso que está en Osceola si usted o de asignar un abogado de oficio de Polk.
But you, of course, can hire a private lawyer if you choose.
Y por supuesto que usted puede contratar un abogado si usted elige hacerlo.
After reviewing the paperwork, I find probable cause.
Después de repasar los documentos, encuentro motivo fundado.
The judge over there wanted you to be held no bond.
El juez de allá quiere que usted quede detenida sin fianza.
It looks like you failed to appear for a plea hearing on a driving while license suspended charge.
Parece ser que usted no compareció para declararse a un cargo de estar conduciendo con la licencia suspendida.
If you don't have anything charge-wise in Polk County, we'll tell them to come get you.
Si no tiene usted ningún cargo pendiente en el condado de Polk, se les notificará para que vengan a buscarla.
If you're still here on May the 7th, we'll bring you back to court to talk to a judge.
Y que si usted aún está aquí para el 7 de mayo, entonces vamos a pedirles que la regresen frente a un juez.
Have a nice day, ma'am.
Que tenga buen día, señora.
Next up is Cynthia Barbosa Castañera.
Barbosa Castañera.
Yes.
Ma'am, you have 2 charges. They are knowingly driving while license suspended and driving a motor vehicle with an expired driver's license more than 6 months.
Señora, tiene usted 2 cargos, uno de estar conduciendo con la licencia suspendida y otro por que la licencia de conducir estaba vencida más de 6 meses.
You want me to appoint the public defender to your case?
¿Quiere usted que yo le asigne un abogado de oficio en su caso?
Sí.
Yes.
I will do that.
Haré eso.
After looking over the paperwork, I find probable cause for the 2 charges.
Ya después de repasar los documentos encuentro que hay motivo fundado para los dos cargos.
I'll set your bond at $1,000 on each of the two misdemeanors.
La fianza va a ser de $1,000 por cargo en estos delitos menores.
I can see that you currently have a hold for ICE.
Y veo que usted actualmente tiene una orden de detención para ICE.
So I'll ask the clerks to prepare a detainer for my signature.
Así que le voy a pedir a la señorita escribana que me prepare una orden de retención para mi firma.
Have a nice
¿Puedo
day.
hacer una pregunta?
Can I ask a question?
Yes, ma'am.
Sí, señora.
Is any chance that I don't get
¿Puedo hablar
deported?
español?
¿Tiene alguna chance que yo no haga la deportación para mi país?
Is there a chance that I won't get deported to my country?
Ma'am, I don't have any answers for you there. I don't handle any of those type of things. That's done at the federal level.
No es una cosa de la que yo me encargo. Este es un asunto federal.
Ok, ¿y tiene algún plazo para que yo salga de acá, me vaya de acá?
Is there a time frame where they have to come and get me?
Well, ma'am, they won't even come to get you until your local charges are over.
Bueno, señora, que no van a venir a buscarla hasta que usted haya resuelto los cargos que tiene aquí.
Or you can always bond out on the local charges and then they'll hold you for them to come get you.
O usted puede pagar la fianza y así la van a detener para que vengan por usted.
Yo pago antes y así viene antes.
¿Cómo?
Yo pago, pronto pago, entonces ellos vienen.
So as soon as I pay, they will come.
No, ma'am, I can't tell you exactly. I can just tell you, once you paid, the sheriff will tell them, all right, you can come get her now. How long they take is up to them.
Bueno, lo que va a pasar, no le puedo decir exactamente el tiempo que van a tomarse, pero ya que usted pague, la agencia del sheriff les va a notificar que ya pagó y que pueden venir por usted. Ahora, ¿cuánto tiempo se demoren para buscarla? No sé.
¿Y cómo hago para pagar?
So how do I do to pay? What do I do?
Ma'am, you have $2,000 cash or surety on these two local charges.
Señora, tiene usted fianza que es un total de $2,000, ya sea en efectivo o con garante.
You have to make arrangements to pay there at the jail.
Y tendrá usted que hacer esos arreglos desde la cárcel.
Ok, gracias.
Okay, thank you.
You're welcome.
De
Next
nada.
up is Miguel Becerra Jose.
Okay.
Good afternoon, sir. You have two charges.
Buenas tardes, señor. Tiene usted dos cargos.
I'm going to read exactly to you what they are.
Y le voy a decir exactamente lo que son.
The first charge is possession of a cast net within the Saddle Creek Park.
El primer cargo es de poseer una red de pesca en el Saddle Creek Park.
The second charge is possession of a cast net while simultaneously possessing game fish.
El segundo cargo es de estar en posesión de una red de pesca y que que simultáneamente usted tenía un pez.
They allege that you were in possession of 9 Florida bass.
Que estaba en posesión de 9 lubinas de la Florida.
Do you want me to appoint the public defender to represent you on these charges?
¿Quiere usted que yo le asigne un abogado de oficio en estos cargos? Señor.
Oiga, yo tengo una pregunta también.
Well, I also have a question.
Well, sir, let's do mine first. I just want to know, do you want the public defender?
Lo único que quiero saber ahora es de que si usted quiere un abogado de oficio.
¿Y eso viene ahorita o pues tengo que esperar?
Well, did the lawyer come right away or do I have to wait?
I have no idea, sir. I'll appoint them and they'll get to you when they can get to you.
Bueno, yo no lo sé, pero yo le puedo asignar uno y cuando ellos vayan a verlo va a depender de cuando puedan hacerlo.
You want the public defender or not?
¿Quiere usted
No.
un abogado de oficio?
No.
No.
If you change your mind, you can always ask at any time in the future.
Si usted cambia de opinión, puede pedirlo en el futuro.
I reviewed the Florida Game Fish and Wildlife Conservation affidavit.
He repasado el affidavit que fue preparado por Florida Game Fish and Wildlife Conservation.
I find there's probable cause.
Y encuentro que hay motivo fundado.
I'll set your bond at $250 on each count.
La fianza va a ser de $250 por cargo.
Now, you do currently have a hold for ICE.
Pero usted actualmente tiene una orden de retención para ICE.
I'll ask the clerks to prepare a detainer that I'll sign.
Y le pediría a la señorita escribana que me prepare una orden de retención para mi firma.
Have a nice day, sir.
Que tenga buen día, señor.
Marie Flores Gallego. Ma'am, you're charged with domestic violence battery.
Señora, ¿tiene usted un cargo de agresión física como violencia intrafamiliar?
¿Me preguntas?
¿Cómo?
¿Me estás preguntando?
Are you asking me?
No, ma'am, I'm just telling you you were charged with domestic violence battery.
No, señora, le estoy informando que tiene usted un cargo de violencia intrafamiliar.
Do you want me to appoint the public defender?
¿Quiere usted que yo le asigne un abogado de oficio?
Sí, señora.
Según señor juez.
Sí, señora.
Yes, Your Honor.
I'll appoint them to represent you.
Le asigno un abogado para que la represente.
I find probable cause and set your bond at $2,500.
Encuentro yo motivo fundado para el cargo. La fianza es de $2,500.
That bond will be a condition of pretrial release.
Y esa fianza va a ser como condición de libertad condicional.
If you post that bond, you must immediately check in with pretrial services.
Y que al pagar la fianza usted deberá de presentarse de inmediato con los servicios de libertad condicional.
After signing up in person, you must call them weekly on Thursdays.
Ya que usted se inscriba con ellos en persona, usted deberá llamarlos cada semana los jueves.
Your special conditions of pretrial are 16, 17, and 18.
Las condiciones especiales de libertad condicional van a ser las números 16, 17 y 18.
You cannot have weapons or firearms in your possession.
¿Tendrá usted prohibido tener armas o armas de fuego en su posesión?
You cannot have any intentional contact with the victim.
¿Y tendrá usted prohibido tener contacto intencional con la víctima?
Stay 500 feet away from the victim as well as his home, vehicle, and place of employment.
Permanecer alejada de la víctima, a más de 500 pies de la víctima, de su casa, de su vehículo o lugar de empleo.
Now, because you lived with him before being arrested, you get to go back there one time.
Y ahora, porque usted vivía con él antes de ser arrestada, usted puede regresar una sola vez.
That one time has to be within 48 hours of your release from custody.
Y esa sola vez tendrá que ser dentro de las 48 horas después de su liberación de la cárcel.
The police have to go along with you while you get your stuff, things like medicine and clothing.
Y la policía debe acompañarla para regresar, para sacar sus cosas, tal como medicina y ropa.
Have a nice day, ma'am.
Que tenga buen día, señora.
Gracias.
And because you do currently have an ICE hold, ma'am, I will
señora,
ask the clerk
señora.
to prepare a detainer for my
Regrese.
signature.
Y porque usted actualmente tiene una orden de retención para inmigración, voy a pedirles que me preparen una orden de retención para mi firma.
Have a nice day.
Que tenga buen día.
Augustin Gonzalez.
¿Puedo preguntar algo?
Agustín González.
has been charged with possession of a cast net within Saddle Creek
Está acusado de estar en posesión de una red de pesca en el parque Saddle Creek
and possession of a cast net while simultaneously possessing game fish.
y que de poseer una red y que durante la posesión simultáneamente estaba usted en posesión de pescados.
Sir, do you want me to appoint the public defender?
¿Desea usted que yo le asigne un abogado de oficio?
Yeah.
Yes.
I'll appoint them.
Se lo asigno.
I've read your affidavit just like the other fellow a moment ago.
He leído el affidavit tal como lo hice con el compañero suyo hace un rato.
I find probable cause and I'll set the bond at $250 per count.
Encuentro que hay motivo fundado, y le voy a dar una fianza de $250 por cargo.
Have a nice day, sir.
Que tenga buen día, señor.
Next up, we have Florentino Mendoza Ramirez.
Florentino Mendoza Ramírez.
Sir, you're charged with operating a motor vehicle without having a driver's license.
Señor, tiene usted un cargo de estar manejando un vehículo sin licencia.
Sí.
That charge has been upgraded 1 degree because of your unlawful entry into the country.
Ese cargo ha sido incrementado un nivel por el hecho de su entrada ilegal a este país.
Would you like for me to appoint the public defender?
¿Quiere usted que yo le asigne un abogado de oficio?
Sí.
Yes.
I will appoint them.
¿Se lo asigno?
Sí.
Yes.
I've looked over your paperwork and I find probable cause for the charge.
He repasado sus documentos y encuentro que hay motivo fundado para el cargo.
Setting your bond at $1,000.
¿Tiene usted una fianza de $1,000?
Ok.
Ok.
Have a nice day, sir.
Que tenga buen día, señor.
They didn't have an ice hold. Do you have an ice holder? You'll show an ice hold?
Only on the,
Because if there is one, I will sign a detainer. Pretrial did. Okay, there's one on the booking sheet.
and
All right, on Mr. Mendoza, I'm going to assign a detainer because there is currently an ice hold.
Para el señor Mendoza voy a firmar una orden de retención, puesto que tiene orden de retención para inmigración.
Next up is Emilio Ramon Montreal.
Emilio Ramón Montreal.
Sí.
Montiel, perdón.
Sí.
Yes.
Sir, you have 3 charges.
Tiene usted 3 cargos.
They are unlawful use of a two-way communication device,
El uso ilegal de un medio de comunicación de 2 vías,
uttering a forged document,
de emitir un documento falsificado
and criminal conspiracy on committing a third-degree felony.
de conspiración para cometer un delito grave en tercer grado.
Would you like for me to appoint the public defender?
¿Quiere usted que yo le asigne un abogado de oficio?
Sí.
Yes.
I'll appoint that office.
Le asigno esa oficina.
I've looked over the paperwork and I find probable cause for these 3 charges.
He repasado los documentos y veo que hay motivo fundado para estos 3 cargos.
Your bond on the criminal conspiracy on a third-degree felony is $1,000.
La fianza por el cargo de conspiración a cometer un delito grave en tercer grado, la fianza es de $1,000.
The bond on the other 2, which are felonies, are $5,000 per count.
Y los otros 2 delitos, que son delitos graves, va a ser una fianza de $5,000 por cada cargo.
Sir, you do currently have a hold for ICE.
Y señor, ¿tiene usted actualmente una orden de retención para ICE?
So I will have the clerks prepare a detainer for my signature.
Así que le voy a pedir a la señorita escribana que me prepare una orden de retención para mi firma.
Have a nice day, sir.
Que tenga buen día, señor.
Right.
Jonathan Valentin.
Jonathan Valentín.
Sir, you're here because you failed to appear for pretrial on 2 separate charges.
Señor, está usted aquí por incomparecer a conferencia preparatoria por 2 cargos separados.
It looks like you already have an attorney on your case.
Y parece que usted ya tiene un abogado en su caso.
I'm finding probable cause based upon the capias that I've reviewed.
Encuentro motivo fundado basándome en la orden de aprehensión que ya repasé.
Judge Gibson wants you held no bond on each, but with a 5-day hearing.
La jueza Gibson quiere que usted quede detenido sin fianza en cada uno de los cargos hasta que tenga usted una audiencia en 5 días.
So I'll hold you no bond and send you to see her on May the 4th at 12:45.
Entonces voy a dejarlo sin fianza hasta que usted vaya a verla el 4 de mayo a las 12:45.
You of course can talk it over with her about a bond at that time.
Para entonces usted puede hablar con ella sobre una fianza.
Next up is Miguel Vasquez Hernandez.
Miguel Vázquez Hernández.
Sir, you are the third and final gentleman charged with these 2 crimes.
Señor, usted es el último de los 3 caballeros acusados de estos 2 cargos.
Possession of a cast net within Saddle Creek Park.
De poseer una red de pesca en el parque Saddle Creek.
And possession of a cast net while simultaneously possessing game fish.
De poseer y también de poseer una red y que simultáneamente poseer pescados.
You want me to appoint the public defender to represent you?
¿Quiere usted que yo le asigne un abogado para estos cargos?
Sí.
Yes.
I'll appoint that office.
¿Le asignaré su oficina?
I reviewed this on your case and find probable cause for the 2 charges.
Ya repasé esto y me encuentro motivo fundado por estos 2 cargos.
I'll set your bond at $250 per count.
Y tendrá usted una fianza de $250 por cargo.
Have a nice day, sir.
Que tenga buen día, señor.
Ms. Cadenas, that's all that I'm aware of.
Okay.
Would you like to?
Your Honor, there was one more I had sent.
Okay, bring them on up.
Batista. Bautista.
Eduardo Bautista Calderon has been charged with driving while license suspended or revoked, a third or subsequent offense.
El señor Eduardo Bautista Calderón tiene un cargo de estar conduciendo con la licencia suspendida o revocada, una tercera o vez subsecuente.
Sir, do you want me to appoint the public defender to represent you?
Señor, ¿quiere que yo le asigne un abogado de oficio para que lo represente?
Sí, está bien.
Yes, that's fine.
I'll appoint that office to represent you.
Le asignaré esa oficina para que lo represente.
I've looked over the paperwork provided and I do find probable cause for this felony.
Encuentro motivo fundado para este delito grave.
I will set your bond at $5,000 cash or surety.
Entonces yo le doy una fianza de $5,000 en efectivo con garante en este caso.
I have just been told that there is currently an ICE hold for you.
Encuentro que, o me acaban de informar que usted actualmente tiene una orden de detención para ICE.
Well, we'll ask the clerks to prepare a detainer for my signature.
Así que les pediré a la señorita escribana que me prepare una orden de retención para mi firma.
Oiga, una pregunta.
I have a question.
Go right ahead, sir.
Dígame.
Como por decir, si agarro el abogado de ahorita del que me está diciendo, ¿cuánto tiempo duraría aquí más?
If I were to get this lawyer that you told me about, how much longer would I be here?
Yes, sir. I really can't answer that. I'll appoint the public defender's office. I don't know what the future holds, though, is how long it will take.
Ah, sí, sí, yo no le puedo contestar yo esto. Yo le asigno a un
Ok.
abogado de oficio, pero no sé lo que lo que viene en el futuro o cuánto tiempo va a tomar.
Es que también pues no tengo ese dinero para pagar para la fianza.
I just
ahorita.
don't have the money to pay the bond.
Sure. If
Claro.
you did pay the bond, they would take you over most likely to the ICE hold.
Ahora que si usted pagara esa fianza, ellos vendrían por usted para llevarlo a un centro de detención.
Or at some point in the future, if that charge gets resolved, they'll then take you over for the ICE hold.
O ya cuando su cargo en el futuro se resuelva, ellos vendrán por usted.
Have a nice day, sir.
Que tenga buen día, señor.
Any others? All right, Ms. Medina, thank you so much. Have a great rest of your.
You too. You too, sir.
All right, everybody. Thank you for your patience. The Spanish and the Creole, those always take a little longer for obvious reasons. We're going to get moving now a little quicker. Just like I've said a couple of times today, there's only 4 things we do today. I tell you what you're charged with. I ask you, do you want the public defender? If you're going to hire a lawyer, just let me know. I determine probable cause, just so you guys know, I've already read all of these affidavits. I didn't think it would be enjoyable for y'all, for me to bring them in here and y'all just sit here and watch me read. So I've already read them. And then the last thing is I talk about a bond. I'll set a bond if it's appropriate or put you on pretrial release. Today's not your trial. As much as I was nice and tried to answer those questions, I'm not your lawyer. I can't give you legal advice. And really, when you ask questions or say things, many times it doesn't work out for you because everything's being recorded. You might try to convince me of something and in the process say something that can be used against you. So it really is not a good idea to ask things or talk about your case, okay? So keep that in mind. Let's start with the gentleman at South County. We'll do the ladies next and then finish up with the men in the back there at Central. Let's call up Roy Baird.
Here. Come on up.
Mr. Baird, you're charged with, looks like tampering with physical evidence. They have you for an ordinance violation of possession of alcohol in the city limits of Lakeland. Do you want the public defender appointed to represent you?
Would you like the public defender to represent you? Yes.
I'll appoint them. I'm finding probable cause because I read this affidavit. The tampering with evidence, that's a felony. So that's $5,000 bond. The open container public consumption is $250. Have a great day, sir.
Still to you, look.
Next up, we have Jackson Brown Smith. Sir, these look to be add-on charges. This is count 8, count 9, and count 10. So you must have already come through first appearances previously. But these are 3 charges of possession of a harmful new legend drug without a prescription. So it's possession of a prescription drug without a prescription. You already have an attorney on the entire case, so there's no reason to reappoint them. I've looked over this habeas. It's a warrant, a bench warrant that was created after the state filed the charges. So I find probable cause. Each of these new charges is a misdemeanor of the 2nd degree, so I'll set your bond at $250 per count. Now, previously you were put on pretrial for the overall case, so I'll make these 3 charges the same pretrial with the same conditions as your earlier case, which looks like you can't have weapons or firearms, and you're not allowed to do any driving of any kind at any time whatsoever, appears to be your conditions. Have a nice day, sir.
All right.
That brings us to Leonard Cologne. I was making sure. I thought we had, just wanted to make sure. So Mr. Cologne was done. He was one of my VOP cases. Next up is Daniel Feliciano.
Judge, he's in, the medical dorm, just got back from court. He's on his way up.
Okay, so he's on his way up to here at the courthouse, 80. He's on the way there.
No, he's in South County Medical. He's on his way up here now.
Okay, couldn't quite hear it, make it out. All right, so we'll put him off to the side. When he gets there, let us know, okay?
Therefore,
All right. And that brings us to Justin Gott. Mr. Gott, you're here for a variety of things. Let me add them up. It looks like a total of 9 different charges over several charging documents. I'll just go ahead and read them off as they are. You're charged with a new case of fleeing to elude. You're charged with a new case of operating a motor vehicle with suspended license with knowledge, a third or subsequent offense, a new resisting without violence, a new attaching a tag not assigned, a new charge of operating a motor vehicle without a driver's license, and a new charge of a possession of a controlled substance without a prescription. Now, in addition to that, you're here because you failed to appear for court on 3 charges, all contained in 25 CF 7749. Those 3 charges are fleeing or attempting to elude, driving while license suspended or revoked, second or subsequent offense, and operating a motor vehicle without a registration. Now, I bet you, and yep, absolutely, on the last 3 that are you failed to appear, you already have a lawyer for. So let me ask you, on the 6 new charges, do you want me to appoint the public defender?
Yes, sir.
Okay, I'll appoint the public defender now, so you have an attorney on all 9 charges. I've looked over, well, the easiest one is the 3 old cases, old charges that you failed to appear for court. I'm finding probable cause. I'm looking at Judge Cumby's habeas. So she issued it sometime back in February. I find probable cause. She wants you held no bond. I'll hold you no bond, but she wants to see you within 5 days. So we've set that up for you to go see her on May the 4th at 8:30. Now let's turn our attention to the 6 new charges. I saw all the citations. I read the FHP affidavit. I did not see anything in the FHP affidavit about controlled substances.
In your Denver Gomez Public Defender's Office, I would agree that is totally absent. And because the only affidavit that's been provided has to do with the alleged fleeing. So there's no way for this court to even review whether there's a basis for the drug charge and.
Yeah, I was just sometimes what's printed up for me, whether it's lost in translation, I always turn to a pretrial representative because they might have more than I was given. So there's nothing more. So Shanaka, what says the state? I don't have anything to hang my hat on as far as the drugs. I'm inclined, unless you want 24 hours to ROR him on that. You tell me.
At this time, Your Honor, I don't have any further information. I think based upon the absence, I think for this situation, that particular charge in ROR would probably be okay.
All right, sir. So I don't know if you can hear that. He's not asking for more time. So on the charge of a controlled substance without a prescription, there is no probable cause. You'll be ROR'd on that charge. I do find probable cause for all the other charges. And candidly, between you and me, if I was able to, I would Parker you on those FTAs, but I can't because you didn't have bonds because you had failed to appear. So I'm factoring in those cases, the old ones, to bump your bonds up on the new ones. So on the fleeing to elude, I'm going to set your bond at $10,000. On the operating a motor vehicle with suspended license with knowledge, third or subsequent offense, it's $7,500. On the resisting without, it's $2,000. On the attaching a tag, it's $1,000. And on the no driver's license, it's $1,000. All right, sir. Have a great day.
Thank you.
Yeah. And we go to, looks like Theodore Grice. Mr. Grice, you're charged with stalking.
Stalking.
Stalking is what they charged you with. Technically, it's stalking, following / harassing or cyber stalking another under Florida statute 784.048. Do you want the public defender?
Yes, what the heck that is? When it?
Yeah, so they're charging you with stalking. So I'll appoint the public defender. I did review it. It's a Winter Haven Police Department affidavit, and it goes into great detail over a long period of time. This alleged victim feels as though she was stalked and explains why. And from that, I find probable cause. I'm going to set your bond at $1,000 and make it a condition of pretrial release. So if you're able to post that bond, you must immediately check in with pretrial services here in Bartow, sign up in person, call them on Thursdays. You have all the standard conditions everybody has, plus special conditions 16 and 17. While on pretrial, you can't use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her home, her vehicles, where she works or where she goes to school. And it goes into great detail about where she lives, her condominium over there in Winter Haven. So I'm going to tell you that you can't go within 500 feet of the event location, which is clearly explained in this affidavit. Have a great day, sir.
Step to your left. Your Honor, we have Feliciano.
Okay, we can circle back and do him now if you'd like.
Thank you.
Let's call up Daniel Feliciano. Sir, you're charged, well, Ms. Goins, on this one.
I would waive the reading.
Okay, just wanted to give you a chance to tell me that.
Yes, sir, thank you.
Sir, you're charged with a felony of the first degree. That charge is punishable up to 30 years in prison. Do you want me to appoint the public defender to represent you?
Yes, sir.
I'll go ahead and appoint that office to represent you. I have reviewed the affidavit from the sheriff. I find probable cause for the charge. Does the state wish to be heard as it relates to bonds?
Yes, Your Honor. May I approach?
Yes, sir.
Your Honor, this is a motion for pretrial detention. Judge, I want to find this motion to be sufficient. The state would request a pretrial detention hearing to be set Monday, May 4th at 1 p.m. on the A2 docket.
Ms. Goins, anything from you?
The focus of a motion to detain for pretrial detention has to do with some kind of danger to the community. And I don't think there's anything just in this particular offense and the circumstances that would justify him being held on a pretrial detention, because it's activity that does not spread in the community. And I think that's the focal point of giving people zero bond, is situations where somehow there's going to be a danger to the public. And there is none here.
State would just point out, Your Honor, that within the motion, it also does talk about the enumerated offense. Without going into specifics, the offense in this case is enumerated under section 907.0415 Delta.
Mr. Feliciano, I have what's in front of me. It's referred to as a motion for pretrial detention. It's based on Florida statute 907.041 as well as Florida rules of criminal procedure. I do, after having reviewed this 2-page document, find that it is legally and facially sufficient. So based upon that and the law that it's based on, I'm going to hold you no bond. But the good news is you're going to go quickly to see the circuit judge, and that'll be on May the 4th. And you'll have the opportunity, the state has an opportunity to put on a full evidentiary hearing in front of that circuit judge to determine whether or not you should stay a no bond or whether or not something should be changed. That'll be at 1 p.m., okay? So we'll hold you no bond, sir, pending that further hearing on the 4th. Have a great day.
Thank you, sir.
You bet. Now we're back to Gregory Griffiths.
Good afternoon, Your Honor.
Good afternoon, sir. As you stand there, you have 6 charges. They are assault on a Leo, battery, a Leo meaning law enforcement officer, battery on a law enforcement officer, disorderly conduct, resisting without violence, trespass, and resisting with violence. Do you want me to appoint the public defender to represent you?
Yes, Your Honor.
Okay, I'll go ahead and appoint the public defender to represent you. Nakagawa, I struggled a little bit with assault on a Leo. So clearly there's an attempted battery, a swing and a miss, and clearly there's a battery on the Leo. I didn't feel like I had enough to hang my hat on for the assault on the Leo based upon representations from the officer that they were in fear and he had a present ability to carry out those threats. It does appear as though there was a swing and a miss, but just didn't feel like, although that might be the basis for an attempted battery, I didn't see where the elements for an assault were there. Give you a chance to disagree with me and point out something I might have overlooked. But I didn't see anything that that I felt like gave me the basis for the elements of an assault on a Leo.
Yeah,
I
and
agree.
just the way that I read the affidavit, Your Honor, just based upon the swing and the swing taken at the law enforcement officer, that's how I interpreted the assault.
Yeah, and I guess that's, I still don't, like I said, it's a swing and a miss it could be attempted battery, but I still think that if it's an assault, the person has to say, oh, I was in fear. It put me in fear because I thought he had the ability to carry out his threat. If you want 24 hours on that one, I can give it to you. If not, I don't believe I should find probable cause, knowing that the state could review this and say, oh, this is an attempted battery. But I just don't think that there's what I need to have for an assault.
That's the time another state would request 24 hours.
Sure. So, Mr. Griffiths, I find probable cause for the resisting with violence, the trespass, the resisting without violence, the disorderly conduct, and the battery on a law enforcement officer. Right now, I don't find probable cause for the assault on the Leo, so I'm going to give the state what they've requested, which is 24 hours to come back with any additional probable cause. But I will go ahead and give you a provisional presumptive bond. So in case you want to bond out between now and tomorrow, you have that right. So having found probable cause, I'm going to set your bond at $5,000 on the resisting with violence, $1,000 on the trespass, $1,000 on the resisting without violence. I'm going to set your bond at $1,000 on the disorderly conduct. I think that's appropriate. I'm going to set your bond at $5,000 on the battery on the Leo, and the presumptive bond that we were talking about on the assault on the Leo. Just to double check your assault on the Leo, it's a misdemeanor of the first degree. I'll go ahead and give you a presumptive bond of $1,000. So how this works is if you bond out between now and tomorrow, well, we won't see you. You bonded out. But if you're still here and you haven't bonded out on everything, they'll bring you back only on the charge of assault on the Leo to see if the state has additional information to provide that judge tomorrow. Okay? And if they don't have any additional information, I suspect the judge tomorrow may ROR you or may view it differently. Have a great day, sir.
May I ask, what's the total bond, Your Honor?
Yeah, go ahead.
What's the total amount in the
Oh,
bond?
the total, I'm sorry. Don't you say it?
Yeah, 14,000.
14,000 as it stands now, sir. Have a great
Could I-
day.
Couldn't be heard on a bond reduction, Your Honor?
Not right now. You just had your first appearance. A little bit of muffle sound, and y'all hear a little bit better than me, I think. All right, next up is, just for the record, I have been told Kyle Gunn bonded. Was told.
Yes.
Okay, Demetrius Heron. Mr. Heron, you're here because the state has filed charges, count 1 and count 2, failure to comply with the registration law. Do you want me to appoint the public defender?
Yes, Your Honor.
I'll appoint the public defender on each one of these third-degree felonies. Find probable cause based upon the paperwork that's been provided, and set your bond at $5,000 per count. That's the standard bond. Have a great day, sir.
Thank you, sir.
Good. Joshua Jablonski. So. Oh, information. Yeah, I do have that. I'm sorry. Thought you said info. I'm thinking information. Sir, you're charged with 1 count. It is, I'm looking at it based upon the information, but it's attempted murder in the 2nd degree. Now, clearly, you've already come through first appearances and already seen a judge. Does he not already have an attorney? Sure.
Let's see.
Not-
Looks like he does, Your Honor. It looks, got regional counsel. Carson.
Yeah, because I saw the companion case. So, sir, yeah, you already came through first appearance, already got public defender. They got off the case because of the co-defendant. You now have regional counsel. You're only back today because the state has reviewed everything from your first appearance and upgraded a charge, and that is attempted murder in the second degree. I find probable cause based upon the state's charging document. The state want to be heard as it relates to bonds.
Yes, Your Honor, because it's a first degree felony punishable by life, state is requesting that the defendant be held in bond.
All right, sir. I think when you originally came through first appearance, this charge was domestic battery by strangulation. I gather that judge gave you a bond of whatever, 5,000, give or take. Because the state has now upgraded that charge, I am going to this first degree PBO.
Yes, Your Honor.
So first degree felony punishable by life. At this point now, I have the ability to hold you no bond. I did review the affidavit. I do believe no bond is appropriate. So I'm going to hold you no bond, but you're on pretrial release for all the other charges. And you have prior conditions 16, 17, 18, and 23. Have a nice day, sir.
And that's pretrial.
Yeah, but you can put pretrial release on it. It really, half a dozen, 1/6 another, because it's no bond. He has pretrial on all the others. All right. Ricardo Jacques. Sir, you have 3 total charges, 2 separate case numbers. It looks like you failed to appear for mandatory docketing on 3 charges. Does he already have an attorney? I gather he does.
Yes, got a public defender.
Yeah, you have the public defender. Usually when people make it all the way to mandatory docketing, they usually will have an attorney. So you have an attorney. I'm finding probable cause based upon Judge Flynn's habeas. He set your bond on the knowingly driving while license suspended at 1,000. On the charge of possession of cannabis and paraphernalia, he set it at $250 per count. Have a great day, sir.
Excuse me, Your Honor, I've been here the whole time.
Okay. Have a great day, sir. I'm not doubting you. I'm just telling you that's what the KPS is. De'Arian Jones. Mr. Jones, you're charged with failing to appear for an arraignment on a charge of trespass.
Hey, Your Honor.
Let him finish.
You want me to appoint the public defender?
Yes, sir.
I'll appoint the public defender. I'm looking at Judge Cole. He's the judge out in the near Haines City out there, the Northeast branch. Finding probable cause, he set your bond at $1,500. You're about to say something? Just don't talk about your case.
Yet. Well, I'm still.
Yeah, don't talk about your case, okay? If you don't have a question, have a great day, sir.
1,500. Yes, sir.
Next up, we have, I believe we're up to Wayne Ricks. Mr. Ricks, you're charged with violating your probation on a felony charge. Do you want me to appoint the public defender? Oh, you already have an attorney. My apologies. I'm finding probable cause based upon Judge Harb's warrant. He signed it 2 days ago. He wants you held no bond. We'll hold you no bond. You'll go to see him on May the 26th. Have a great day.
Thank you.
Yeah. Eves St. Clair.
Judge, he's still being combative.
Mr. St. Clair's being combative. It looks like it's 2 days in a row. You want to go ahead and handle this now, Ms. Goins, or because right now he's being held no bond. I can plan to give him a bond.
Well, yes, Deborah Goins, on behalf of Mr. St. Clair, I would ask if I would go ahead and proceed with the first appearance.
Okay. Mr. Eves Jerry St. Clair is charged with resisting without violence, but it's been upgraded to a 3rd-degree felony based upon his unlawful entry in the country. I'll appoint the public defender. I reviewed the sheriff's affidavit, finding probable cause. His bond is $5,000 on that F3. And because he has an an ICE hold, I'll ask the clerk to prepare a detainer. All right. And we have moved on to Jermaine Thompson.
You consent to set us to represent me.
Mr. Thompson, you're charged with resisting without violence. Do you want me to appoint the public defender to represent you?
I think that makes the 3rd one, right?
I don't know what you're talking about, sir. I just know that you're here on a charge of resisting without. I can also tell you that you're in jail on an open case that you're currently on pretrial release for. So do you want the public defender?
Yes, I actually was in front of you yesterday with
Yes, sir.
with two resisting arrests, and I was telling you about that situation. The officer said for me to handle my situation like a man, and then they beat me afterwards. I don't know if you remember me talking to you about it, but my public defender was there.
Yes, sir. I absolutely remember our conversation, and candidly, I wasn't following because you obviously knew more about some situations than I did. So I didn't follow you completely, but now I can see that you're back in front of me on a new charge. So do you want the public defender on this one?
I'm gonna need one, but I've been represented by the Queen of England, but I'm gonna need one for what's going on here.
Yeah, let's go ahead and appoint the public defender on this charge. I have reviewed this affidavit. It looks like the allegations occurred on the 28th. So, and the day is, make sure I got my dates right, the 30th. So I saw you on the 29th yesterday for unrelated charges, and you were talking about something that, again, I went over my head because I didn't know anything about it. Now I realize what you were trying to talk about yesterday was something that occurred the day before, allegedly. So I'm going to find probable cause. I'm going to set your bond at $1,000 on this charge. But I do think it's appropriate that you were on pretrial release while you're in custody on 25 CF 10259. I think it's appropriate because you picked up new charges while on pretrial release that I revoked your pretrial release. And I hold you no bond pursuant to the authority of Parker versus State, which I'll do. And if by chance you don't already have the public defender on that felony, I'll appoint them to represent you. Have a great day, sir.
Up to your left.
I understood.
Up to your left.
I think we're done with all the folks there in South County. Have a good day, Deputy. Moving on to the. I'm sorry, go right ahead, Ms. Goins.
Yeah, what happened with Pleaker?
Pleaker was called up earlier.
Was it real interpreter?
Oh, that's
Yeah.
correct, sorry.
Yeah.
What's the case?
Okay.
Yeah, okay. CF 25-10259. Okay, thank you. Moving right along for everyone, looks like Alfaro is not available, is what I was told. Okay.
Is Alfaro in medical?
Correct.
That is correct.
Okay, thank you.
Moving on to Dwayne Allen Arts.
Twin Arts.
I'm sorry, ma'am, Dwayne, I should have. I got it color coded, but I didn't register. My apologies.
It's okay.
Twin Arts, ma'am, you're charged with failing to appear for arraignment on the charge of petty theft. Do you want the public defender?
Yes, ma'am. Yes, sir.
Okay, I'll appoint them to represent you. I'm looking at your capias that I was the judge that was presiding that day. So I set your bond at $2,000 cash or surety. That is, so if there's probable cause, 2,000 cash or surety. I can tell you that you're scheduled to come see another judge on May the 15th. We'll try to get you in front of that judge quickly. Have a great day.
Thank you. All right, thank you.
I think we are up to Charlotte Barnes.
Yep.
Right. Miss Barnes, just going through my paperwork that folks I'd already called and didn't pull the papers out. Miss Barnes, you're charged with possession of cocaine, possession of paraphernalia, and tampering with physical evidence. Do you want the public defender?
Yeah, I need one.
I'll appoint them. Finding probable cause, your bond on the two felonies, the tampering and the cocaine, will be $5,000. Your bond on the misdemeanor paraphernalia is $1,000. $11,000 total. Have a great day, ma'am. And so we all know Isamar Cedeno bonded. That would bring us to Tiffany Kraus. Ms. Kraus,
Yes.
You're charged with domestic violence battery. Do you want the public defender?
Yes, Your Honor, please.
I'll appoint the public defender to represent you. I've looked over your affidavit from the sheriff and I find probable cause. I'm going to set your bond at $2,500. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person with them, and call them weekly on Thursdays while your case is pending. You have all the standard conditions that everyone else has on pretrial, but based upon your charges, I'm going to order that 16, 17, and 18 are your special conditions. They read that you're not allowed to have weapons, firearms, or ammunition in your possession. You cannot have any intentional contact with the listed victim. Stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. Because you lived with him prior to being arrested, you will
And
be
he is my
allowed.
husband, and I have a child with him as well, Your Honor.
Yes, ma'am, I totally get that. The reason I'm
Yes,
telling
sir.
you to stay away from him is
Yes, sir.
keep him from being safe. And
Right,
then
yes, sir.
the alleged victim. And
Of
just so
course.
you know, and everybody behind you, anything I do today, I may or may, if you're a misdemeanor, you may have me as your judge. If you're a felony, you'll have someone else as a judge. So my point is whatever I do today, the judge assigned to your case can go behind me and change it if they have a hearing and they believe it's the right thing to do. But
Yes,
for
Your Honor.
purposes of today, I'm going to do 16, 17, and 18. 18 says that you are allowed to go back to that home one time to get your stuff.
With an officer, correct?
Yeah, with an officer so they can keep the peace, and you have to do that within 2 days. And usually that's things like medicine, clothing.
Yes,
work,
sir.
Stuff like that. Have a great day, ma'am.
Thank you, Your Honor.
Yeah. Stephanie Dobbs.
Yes, Your Honor.
Ms. Dobbs, you're charged with petty theft. You want the public defender?
No, I do have a question. I am not from the state. My plane leaves Saturday. What can I do?
Ms. Dobbs, I'm about to give you a bond, but I might give you a higher bond now based upon what you told me. Because think about it like this. Bond is not meant to punish you. Hold on, let me get it out. Bond is not meant to punish you. Bond is meant to make sure you come back to court because everybody's innocent until they've proven to be guilty. So go ahead. I'll stop talking. You tell me what you want to talk, then I'll listen patiently. When you're done, I'll finish up. Go ahead.
Okay. I was wondering if I can get a virtual appearance, being all the way in Maine.
And I may or may not be your judge because there's more than one judge that does misdemeanor petty thefts. There's 4 of us that do it here in Bartow, and we have 1 in Lakeland and 1 in Haines City. So there's a 1 in 6 chance I may be your judge. I don't want to answer for those other 5. Now, if you're assigned to me, send me a request in writing or email. My assistant will print it up for me. And if you live in Maine and you want to appear virtually, I normally let people do that kind of thing. But again, I don't want to speak for those other 5 because they might not do things the way I do. Okay.
Okay.
All right. So ma'am, having reviewed you said you don't want the public defender.
No. Sorry.
Fair enough. Just know you can always change your mind and ask for one later. I find probable cause based upon the Auburndale PD. This allegedly took place at the Auburndale Walmart right there on 92. I'm finding probable cause. I'm going to set your bond. I think because you don't live here, have no ties to this area, I really think there needs to be a bump in the bond. I'm going to set your bond at $500 cash or surety. Now, if you bond out, you got to come to court. And if you don't come to court, like I said, they'll issue a capias for you. Now, if you get a judge, it looks like you're going to, right now, you're scheduled to see Judge Gibson. That's who you're scheduled to see right now. If you bond out, they may change it, give you to another judge and push your date back. But yeah, if you're still in custody, you'll come see her. If you bond out, then whatever judge you get assigned to, you can make that request about virtual appearance.
Okay.
Just know this, and I'm trying to give you some things to think about. If at some point in the future you want to plead guilty or no contest, you got to be present in the courthouse. Why? Because we got to roll your fingerprints because we use those to prove, if you go in and commit new petty thefts, it elevates to a felony. Now they prove it is through fingerprints. So at some point, if you want to enter a plea, you got to be present. At some point, if you want to go to a trial, which you're entitled to, you got to be present. Okay. So just keep that in the back of your mind that at some point, short of the state dropping it, you're gonna have to come to court at some point. All right.
Okay.
Have a great
you.
day, ma'am. I think we are up to Nakia Gillen.
Yes.
Welcome, ma'am. You were charged with possession of cannabis, possession of drug paraphernalia, and you've been charged with trafficking in oxycodone greater than 7 grams. Do you want the public defender?
Yes.
I'll appoint that office to represent you. I've looked over the sheriff's affidavit and I find probable cause. Just so you're aware, it looks like it's 8.2 grams. They allege it's 18 different pills that come up to that 8.2 grams. So I find probable cause. Does the state wish to be heard?
Yes, Your Honor. May I approach?
Sure.
Your Honor, this is a motion for pretrial detention as it relates to the trafficking charge. Should Your Honor find this motion to be sufficient, the state would request a probable or pretrial detention hearing to be set on Monday, May 4th at 1 p.m. on the A2 docket.
Anything from the defense?
No, sir, I don't have any comments at this point.
Ma'am, I have a motion for pretrial detention in front of me. It's based on Florida Rule of Criminal Procedure and Florida Statute 907.0415C. I'm finding it to be legally and facially sufficient. As a result of that, I'm going to hold you no bond, just on the trafficking charge. And I'm going to send you to the circuit judge who handles felonies, and that'll be quickly. That'll be on May the 4th at 1 p.m. Now, on the other charges that we found probable cause, I'll set your bond at $1,000 per count. But again, before you go rush off to bond out on those two, you can't go anywhere until you get a bond on the trafficking, okay? So $1,000 on the marijuana and paraphernalia, no bond on the trafficking. Have a great day.
Thanks.
You bet. We are up to Felicia Harris. Ms. Harris, you're charged with domestic violence, aggravated assault. Looks like it's 2 separate counts. Do you want the public defender?
Yes.
I'll point them to represent you. I've read this affidavit. It's from the sheriff. I find probable cause, setting your bond on each of them at $5,000 apiece, $10,000 total. Those bonds are conditions of pretrial release. If you post those bonds, you must immediately check in with pretrial services, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus special conditions 16, 17, and I'll do a special condition 27. 16, 17, and 18 are you cannot have weapons or firearms or ammunition in your possession. 17 says you cannot have any intentional contact with either of the 2 victims, directly, indirectly, or through a third party. Stay 500 feet away from them, their home, their vehicles, and where they work. And because you lived there with those 2 victims prior to being arrested, you get to go back one time with the police within 48 hours of you getting out of jail to retrieve your essentials like medicine and clothing. Condition 27 is a catch-all. It's other. I'm going to order that you take all medications that have been legally prescribed to you by a doctor. Have a great day, ma'am.
Sir, can I say something?
Sure, just don't talk about your case, okay? That's probably not a good idea.
I have a daughter.
Yes, ma'am.
Can I allow him to see my daughter?
I didn't do anything to prevent you from seeing your daughter, and I don't know what DCF may or may not be doing, but I haven't done anything to prevent you from seeing your daughter, just the 2 victims, which are other family members. Have a great day, ma'am. We are up to Christy Hornsby.
Yes, sir.
Ms. Hornsby, you're charged with domestic battery. Do you want me to appoint the public defender?
Yes, sir.
I will. I've looked over the sheriff's affidavit. There's probable cause. Your bond is $2,500. I'll make it a condition of pretrial release. If you make that bond, you have to immediately check in with pretrial services, sign up in person with them, calling them on Thursdays, all the standard conditions plus special conditions 16, 17, and 18, which of course you've heard already, but it's you can't have weapons or firearms in your possession. You can't have any intentional contact with the victim. Stay 500 feet away from him, his home, his vehicles, where he works or where he goes to school. It looks like you had the same address prior to being arrested. So I'll let you go back there one time within 48 hours of you getting out of jail with the police to get all your important essential stuff, like your medicine and your clothing and things like that. Have a great day, ma'am.
Thank you.
Good. We are up to Katie Knotts.
Yes, sir.
She's charged with burglary with an assault or a battery. Burglary with an assault or a battery. Ma'am, that is a first-degree felony punishable by life. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint a public defender to represent you. Ma'am, I've looked over this affidavit from the Lakeland Police Department. I do find probable cause. State wishes to be heard as it relates to bonds.
Yes, Your Honor, as this is a first degree felony punishable by life, state requesting the plea can be of no bond.
On this one, if it's my discretion, which it is what you're asking, I'm not going to do it on this one. If you want time to
Yes,
file your
state would request 24 hours and has the intention to file a motion for pretrial detention.
Okay. Ma'am, just so you know, that particular charge, a judge has the discretion to hold you no bond. You know, not every charge is created equal. Sometimes a burglary and a battery is more egregious in my eyes than others. So yours, I don't want to hold you no bond just because I can. But now the state, knowing that I made that decision, is saying, Judge, we're going to now pull out the law and the rule of procedure, and we're going to file a motion. Can you give us 24 hours to do that? And I think that's appropriate for me to do that. So I'm going to hold you no bond and give them a chance to file their motion. We'll be bringing you back tomorrow, okay?
Yes, sir.
All right, have a great day. That brings us to Lacaricia Lachey Nimmons.
LaCarsha, Your Honor.
I apologize. I apologize. Say that again for me.
LaCarsha.
Harsh. Miss Nimmons, you're charged with violating your probation on a possession of cocaine. Do you want the public defender?
Well, I've already been here on the 18th, I think, for a first appearance for both of those. They resolved them then.
Yes, ma'am, you're right. I asked it because it's habit, but if I had looked a little closer, the public defenders have already captured that information and put it there for me to see. But you're right, you've already come through first appearances. What normally happens is someone might get arrested and brought into jail on a warrantless bop for whatever reason. It could be curfew violation, it could be committing a new crime, it could be a whole bunch of things. But they don't have a warrant for it. They brought you in on a warrantless situation. Yeah. And so
because they didn't notify my PO that I were already in custody.
Well, that's what I'm about to tell you. It could be a variety of things, like you were arrested for that, or the clerk just whispered in my ear and says, the police arrested you for something else, and the judge, and it could have even been me, was told, hey, Judge, she's on probation. So when the judge finds out you're on probation, even though you weren't arrested for it, the judge can take you into custody on an instanter. Well, now that all that's done, now your probation officers learned about whatever it was that caused the judge to take you into custody. They prepared an affidavit, they sent it to the judge, and your assigned judge has now signed a warrant. So we're basically, the paperwork is catching up with what allegedly happened, the alleged facts. So to your point, you already have an attorney. There's probable cause. I'm looking at the warrant. I'm going to hold you no bond. You'll go see your judge on the 19th. Have a great day.
So I've already had a court date for both. They combined them for the battery and the VOP is what I was saying, Your Honor. So
yeah,
I didn't understand why I were here at another second appearance.
Yeah, I was just trying to explain it to you. It is some kind of, it basically as a judge, it's twice the work for us because we've already done it, but now there's a new reason why you're being held, and that's because Judge Harb signed a warrant 2 days ago. And that was once he figured out that you were in jail for allegedly for doing something that caused it. Have a great day, ma'am.
Yes, sir.
All right, we have Takiria Odom.
She was being combative and was not brought up.
All right, do you want to try again tomorrow, or go ahead? She's being held on a no bond, and I'm about to give her a bond.
Yes, on this item, I think I have a little, she's a bring back from yesterday also.
Okay, so.
Yes, I go, this is Deborah Roy's on behalf of Minnesota. I would ask to go ahead with the first appearance on her behalf.
Sure. Mr. Kyria Odom is charged with trespass on property other than a structure or a conveyance. I'll appoint the public defender. I find probable cause. It looks like it's a 7-Eleven on Memorial. I'm going to set her bond at $1,000. We are up to Nancy Sharpless, who I think I called her name yesterday. Is it Sharpless or Sharples?
Sharples.
I knew there wasn't two S's, but I went with Sharpless first, but I thought Sharples might be my second guess. Ms. Sharples, you're charged with DUI, driving under the influence, and it looks like you have a prior DUI in Polk. Do you know when that was? So just so you know, a DUI with a prior, that's punishable up to 9 months in jail. Do you want me to appoint the public defender, or are you going to hire a lawyer that you get to pick?
Appoint a public defender, Your Honor.
It looks like it's 1989, so we're going back a few years. But I'll appoint the public defender to represent you. I've looked over your affidavit. It's a City of Winter Haven affidavit, and I find probable cause for the charge. I'm going to set your bond. You have a prior, so I'm going to set your bond at $2,000 cash or surety, and I'll make it a condition of pretrial release. So if you're able to post that bond and you are released, you need to check in with pretrial services, sign up in person, and call them on Thursdays while your case is active. You have all the standard conditions plus special conditions 13 and 14. I don't want you to have any, I don't want you to possess alcohol. I don't want you to consume alcohol. So no holding it or no drinking it. And
Right.
You're not allowed to go to any bars, no nightclubs, no lounges, no place like that. And to make sure you're following those rules, I'm going to put you on some random urine testing, but it's urine testing for alcohol. So they're going to give you a color and they'll give you a number to call 5 days a week to see if that color is mentioned. And if it is, then the very next day you got to come down and give a urine test. Okay?
Okay. Yes, sir.
That's at your expense, the urine test. All right, ma'am. Have a great day.
Thank you.
Yeah. We are up to Zoe Strickland. Ms. Strickland, you're charged with domestic battery. Do you want the public defender?
Yes.
I'll appoint that office to represent you. I've looked over the City of Winter Haven Police Department's affidavit. I find probable cause, setting your bond at $2,500, but I make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Thursdays, all the standard conditions, plus special conditions 16 and 17, which says you can't have weapons or firearms in your possession, and you can't have any intentional contact with the listed victim. That's directly, indirectly, or through a third party. Stay 500 feet away from him, his home, his vehicles, where he works or where he goes to school. Have a great day, ma'am.
Thank you, you too.
Yeah. Amanda Zeller. Ms. Zeller, you are charged with possession of methamphetamine, possession of cocaine. I'm sorry, I take that back. Possession of methamphetamine, possession of drug paraphernalia. One felony, one misdemeanor. You want the public defender?
Yes.
I'll appoint him to represent you. Looked over the City of Winter Haven, actually, it's the sheriff, I can take that back. The sheriff's affidavit, finding probable cause, setting your bond at $5,000 on the meth, $1,000 on the paraphernalia. Have a nice day. All right, on to the gentleman. We have Herbert Allen is charged with domestic battery by strangulation. The strangulation makes it a felony. Sir, do you want the public defender?
Yes, sir.
I'll appoint that office to represent you. I've looked over the sheriff's affidavit on this third-degree felony, finding probable cause, setting your bond at $5,000, making it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Thursdays, all the standard conditions. But based upon the allegations in the victim comment sheet, I'm going to tell you that you're not allowed to be in possession of alcohol. You can't consume alcohol, can't go to bars, nightclubs, or lounges. You'll be subject to random urinalysis for alcohol. In addition to that, conditions 16, 17, and 18, you can't possess firearms, weapons, or ammunition. No contact with the alleged victim. Stay 500 feet away from her home, her vehicle, where she works, or where she goes to school. And it does look like you shared an address with her, the best I can tell. So I'll let you go back there one time if you want to, with the police within 48 hours of you getting out of jail, if that occurs, to retrieve your essentials like medicine and clothing. Good luck to you.
Thank you, sir.
We're up to Cecil Baker. Mr. Baker, you're charged with possession of methamphetamine, possession of drug paraphernalia, fleeing to elude, operating a motor vehicle that's unregistered, possession of marijuana known as cannabis, operating a motorcycle without a license, and resisting an officer without violence. Do you want me to appoint the public defender to represent you?
Yes, sir.
I'll appoint that office to represent you.
Your Honor,
Yeah.
I'm going to make sure. Deborah Goins from the Public Defender's Office. I wanted to check because in this instance, there were a number of things listed as the offenses. And they were speaking about not having an endorsement for a motorcycle. So does that may fall under the operate a motorcycle without a license? I don't know. But that's what was charged in the, that's right. The affidavit lists it that way, but you know, in my booking sheet, I had that additional charge of without an endorsement for motorcycle. So I don't think that's an issue anymore because that isn't how they put it in the affidavit.
Yeah, I understand what you're saying. Sometimes it's just not operating a vehicle without a license. Other times it's operating a motorcycle without an endorsement. It only looks like they charged him with one of those two things, which was operating a motorcycle without a license under 322.03 subsection 5. So instead of charging both, it only looks like it's one. You agree?
And I'm trying to find it where it says that he has no license.
You looking at that?
See.
They're charging him with operating a motorcycle with no endorsement. So the allegation is he might have a license, but he didn't have the endorsement for operating a motorcycle.
Well, that's why I was looking at the affidavit, which is I always do because that's sure. That's not the offense listed on the front of their affidavit. They were just saying operating a motor vehicle without a license. But I was also looking to see where do they have anything in the affidavit that even states that he doesn't have a license. And they apparently did not specifically, although unless it just didn't get put on the front of the affidavit, I didn't see where they listed the endorsement. And I also don't see anything in the affidavit.
Just so we're on the same page, I don't think they're alleging that he doesn't have a driver's license.
Right.
They just allege that he didn't have an endorsement.
Right.
So from that same page, the fact that they said based upon the above, Baker is being charged with operating a motorcycle without an endorsement. Do you think they need more information than telling us he's operating a motorcycle without an endorsement?
Yes.
Sometimes in life, it just seems like the charge itself, describing the charge describes the facts.
Well, but that would have to be a DMV thing. So what I mean is their record checking, they found out that the vehicle was unregistered. Along that same lines, they should have had information that would verify that he didn't have an endorsement for a motorcycle. And it isn't there. Because it's another crime. I mean, you can have a driver's license but not have an endorsement for a motorcycle. But I don't see anything in the affidavit that supports that other than the officer said, I'm charging him. I'm going to charge him for operating a motorcycle without an endorsement.
What says the state?
The state would point out, Your Honor, in the first paragraph, it does say that he was identified through the DMV system, David, which is presumably where they got that information. They would argue that there's enough at this point for probable cause purposes. However, Your Honor is not inclined to find probable cause on that. The state has 24 hours to protect probable cause. I think that this is a fairly minor issue.
Yeah, no, and I think Ms. Goins is right. I would say that it's kind of, I don't want to say ticky-tacky, but it's, you know, I mean, when you charge someone with not operating a motorcycle without an endorsement, that charge itself explains to you exactly what they're saying has happened. But to her point, there's no mention in there. Now, how do you put one extra sentence? I checked his license and he has no endorsement, and I suspect that's all that's needed to get us, but he didn't do that, to your point.
He did
So-
not, and
so-
we can't assume
I agree.
there's a basis for it.
I agree. And that's why, like I said, I think it's, that I should find no probable cause for that charge. And I'll give the state 24 hours to try to perfect probable cause. So, sir, I'm going to give you bonds on everything else, but the point is I want to give you a bond on that one too. Just like the fella, if you bond out because all I'm doing today is deciding if you get out of jail or if you have a bond. My decision doesn't determine what you're charged with. That's the state's decision.
Yes, sir.
So I can find no probable cause, and they can turn around and say, we disagree with you, Judge Stamey. We did more investigation, we're charging him, and they have that ability to do it. So all I'm doing is making decisions about you being bondable or not.
Yes, sir.
So that understanding, let's go down it again. I find probable cause for everything except for operating a motorcycle without a endorsement. They didn't say you didn't have a license or saying you didn't get your motorcycle endorsement. You got to take a class and all that good stuff and pay money
Yes,
to
sir.
get it. Say you don't have it. So for that one, there's no probable cause. We'll bring you back tomorrow if you're still here. I am going to set your bond, a presumptive bond on that at $250. So are able to bond out between now and tomorrow if you choose to. Now, on everything else, I find probable cause, and I will tell you that I'm aware that you also have an open case 26 CF 2347, which has some very similar charges for what you're here for, having been arrested yesterday. So I'm going to bump your bonds up based upon that. On the possession of paraphernalia, I'll set your bond at $2,000. On the fleeing to elude, it's $7,500. Possession of meth is $7,500. The unregistered motor vehicle is $500. The possession of cannabis is $1,000. Resisting without, we'll do $1,000. And
Yes,
then, of
sir.
course, presumptive bond of $250 on the motorcycle endorsement. Now, having given you bonds on all of these that I found probable cause for, I am going to revoke your bond on 26 CF 2347 and hold you no bond pursuant to the authority of Parker versus State and appoint the public defender if you weren't already appointed the public defender. Have a great day, sir.
Yes, sir.
I was trying to say that ticky-tacky is not a legal term. And I do remember reading case law where they talk about nitpicking is a legal term that you use sometimes. Neither one of those is, you're saying that was an accurate challenge that I'm glad I was able to look closely and agree with you. But I was just letting you know that it was one of those things that I feel like I know what the officer's allegation is, there just was no support. Have a great day, sir. Next up is Eduardo Bautista Calderon. Oh, we did him already.
Burgess?
Keelan Burgess. Mr. Burgess, you are charged with domestic violence battery. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint the public defender. You're charged with domestic battery. Appoint the public defender. I've looked over this Lakeland Police Department affidavit. After I reviewed it back in my office, I find probable cause. I'm going to set your bond at $2,500 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial, sign up in person, call them on Thursdays. All the standard conditions plus special conditions 16, and 17, which is no weapons or firearms can be possessed, and you can't have any intentional contact with the victim. Stay 500 feet away from her, her home, her vehicles, where she works, or where she goes to school. Have a great day, sir.
Have a seat.
Tyler Doan. Mr. Doan, you're charged with resisting an officer without violence and a VOP for petty theft, a felony variety. Do you want the public defender?
Yes, sir.
I'll appoint them to represent you. I'm finding probable cause for each based upon this paperwork that I'm looking at here. On the VOP, that was Judge Harv. He's already found probable cause. He wants you held no bond. We'll do just that. And on the resisting without, I'll set your bond at $2,000. Have a great day, sir. Looks like we're up to Brian Ducharme. Mr. Ducharme, it looks like you're charged with career offender failure to register. You want the public defender?
Yes, sir. I got a question.
All right, one second. Go ahead. Go ahead.
I registered in Orlando because I couldn't make it to Polk County. Okay, on the 26th of January. That was on Young John Parkway in Orlando.
I'm not trying to be critical, but that wasn't a question. That was a statement. And I really try to keep you guys from making statements.
Sorry about that, sir.
I'm not picking on you. I'm just saying, usually when someone says, Judge, can I make a statement? I say, please don't. It's being recorded. You said,
Yes,
hey,
sir.
Judge, can I ask a question? You just didn't ask a question. You just made a statement that candidly talks about your charge. So I try to keep you guys from doing that for fear that you might say something you wish you hadn't. So, sir, you're charged with a career offender failure to register. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint the public defender. Finding probable cause, because another judge has already reviewed this. Judge Patey reviewed it way back early March, found probable cause. So I find probable cause as well, and I'll set your bond at the standard bond for an F3. That's $5,000. Have a great day, sir. Next up is Carlos Gomez Perez. Did we do that one? We did. All right. And that brings us to, we did Augustin Gonzalez as well. We are up to Charles Grinison.
Good afternoon, Your Honor.
Good afternoon, sir. You're charged with domestic violence battery. That's a misdemeanor. Do you want me to appoint the public defender to represent you?
Yes, sir.
I'll go ahead and appoint the public defender. I have the Haines City Police Department affidavit right here in front of me. I do find probable cause after I've reviewed it. Looks like you are on active probation for a criminal traffic. So what I'm going to do, sir, is I'm going to set your bond at $5,000 cash or surety and make it a condition of pretrial release. As it turns out, the alleged victim was contacted and she wishes to have contact with you. She doesn't object to you getting out of jail. She's indicated that she doesn't want to press charges. So what I'm going to do is I'm going to make your $5,000 bond a condition of pretrial release. If you're able to post it, you must immediately check in with pretrial services, sign up in person, call them on Thursdays, all the standard conditions that everyone else has, plus the following special conditions. Condition 16 says you can't have any weapons or firearms in your possession while on pretrial. And condition 20, based upon the victim's wishes, I am going to allow you to have contact with her, but this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. Now, because you're on probation, I'm going to take you into custody and hold you no bond as an instanter warrant on 25 CT 2512, and I'll appoint a public defender to represent you on that violation of probation. Have a great day, sir.
Your Honor, when will my next court date be for the probation?
Well, the new charge is going to be on May the 15th. Let's see if the clerks even have a date prepared for you.
Probably not if it's still probation. What's that up to be here with the new charge?
Sounds like you're going to go both of them on the 15th. That's not a bad turnaround. It's pretty quick. So May 15th for both. Have a great day, sir.
Thank you.
You bet. Christopher Harris has been charged with operating a motor vehicle without a license, felony possession of cannabis resin, operating a motor vehicle without a registration, and possession of drug paraphernalia. Do you want the public defender?
Yes, Your Honor.
I'll appoint him to represent you. I've
Thank you.
looked over this affidavit I'm holding from the sheriff. There is probable cause. On the no valid DL, it's $250 for the bond. The big one for you is the cannabis resin. Believe it or not, that's a felony because it's resin.
Yes,
So
Your
that's
Honor.
$5,000. The no motor vehicle registration is $250 and the paraphernalia is $1,000. Good luck to you, sir.
I have one question.
Sure.
Are we able to review the operation without a driver's license?
Yeah, I can go back and look at it. Let's see.
Okay, just in the affidavit, please.
Yeah, they gave you a citation that charges you under 320.02 is the no registration. And then they charge you by citation with no driver's license. It says you've never had one issued.
Yeah, I've never.
Don't talk about it. I'm just letting you know what
Okay,
they wrote
sorry.
down.
Yes, Your Honor. I'm sorry.
3. So let me take a look to see what the information is in here. All right, so I'm just reading third from the bottom paragraph, and again, don't comment, but it says an FCIC NCIC check was confirmed that Christopher does not have an active medical marijuana card in the state of Florida, period. It also discovered that Christopher does not have a valid driver's license in the state of Florida. So there you go.
Okay. All right. Thank you, Your Honor.
Yeah, have a great day, sir.
You as well.
Charles Andrew Johnson, I think we did him, did we not?
Yes.
I thought so. Ricky Kearse. Sir, you're charged with possession of cocaine. Do you want the public defender?
Yes, sir.
I'll appoint him. Looking at the Lake Wells PD affidavit, finding probable cause, setting your bond at $5,000. Have a great day.
What was that name, Your Honor?
Kearse with a K, K-E-R-C-E. Ricky's the first name.
Okay.
I think we're up to Jeffrey Lewis, who's charged with possession of meth and possession of paraphernalia. Mr. Lewis, do you want the public defender?
Yes, sir, please.
I'll appoint the public defender. I've looked over the sheriff's affidavit back in my office, finding probable cause, setting your bond at the standard bonds, which is $5,000 for the meth, $1,000 for the paraphernalia. Have a great day.
Yes, sir. Do I have a court date?
I can give you that. If, looks like Mr. Devon,
It's June. Second.
June 2nd, sir. June 2nd. Have a great day. Manuel McGree, Gerardo Manuel McGree. Sir, you're here on, looks like 3 different, well, not even 3. Looks like 1, 2, 3 FTAs. So 3 things you failed to appear for court in Polk County. Then you have 2 brand new charges, and then you have a child support matter out of Highlands County. So on everything except for the child support out of Highlands County, do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you. Now, on that one, the child support, you can hire a lawyer if you want. It's just civil in nature, so I can't appoint a public defender. But everything else, you get the public defender. I have looked over the paperwork that's been provided to me, and I find probable cause for all 6 charges. The easy one that we'll start with is that child support warrant out of Highlands County. They find probable cause, and the judge there set you to a purge at $542. You can purge out on that one for $542. Now, on the criminal matters, having found probable cause, going to set your bond on the resisting without at $2,500. On the battery on a law enforcement officer at $7,500. The failure to appears on the petty theft, the judge in that case with a prior conviction set your bond at $2,500. On the assault with an intent to do violence, the judge on that older case set your bond at $1,000. And lastly, on the driving while license suspended, second or subsequent conviction, the judge there set your bond at $2,500. So let me add it up. It looks like looks like it's about $16,000, and then the purge on top of that. Have a great day, sir. Ernest Martinez is here on 2 separate violations of probation. Do you want the public defender?
No, Your Honor. I have an attorney.
Fair enough. If you change your mind, you can always ask later. I'm looking at Judge Harb's warrant. He signed it on the 9th day of January, finding probable cause, holding you no bond. Have a great day, sir. Michael Joseph Michael.
He refused.
Michael Joseph Michael refused. Ms. Goins, you want to try back tomorrow on that one? Or
Yes.
your VOP, so there are no bonds, so I wouldn't be giving him a bond anyway. So let's just try back tomorrow.
Yes, sir.
Yeah. We are up to Antonio Morris. Mr. Morris is charged with a warrant out of Hillsborough County, 2 charges, possession of cannabis, carrying a concealed firearm. I cannot appoint a public defender, sir, because it's a different circuit. You can hire a lawyer or ask for a public defender when you get back to Tampa. I've looked over your paperwork. I find probable cause. The judge over in Tampa has already determined that you should not get a bond, so I'll hold you no bond. If there's nothing in our jail that's keeping you here, like a local charge, then this jail will call Tampa and tell them to come get you. If they haven't come to get you by this time next week, we'll bring you back on May the 7th to talk it over with the judge at first appearance. Have a great day.
Excuse me. I tried to get a continuance on my court date.
Yes, sir. I don't know anything about that. I can just tell you that that judge over there, issued the warrants and they're for no bond. So that's really, any issues with him issuing that warrant is between you and him or her, whichever. Have a good day, sir. Next up is David Punger.
I have a challenge to make on that when you're ready, Your Honor.
Sure. Sir, you're charged with burglary burglary of an unoccupied structure and criminal mischief $1,000 or more. Sir, do you want the public defender?
Yes.
I'll appoint them. Go right ahead, Ms. Goins.
Yes, sir. I challenge probable cause on the criminal mischief charge. I do not see anything in the affidavit that addresses an amount of damage that was done, and that is an essential element. I do see where the officer charged criminal mischief $1,000 or more. I just didn't see where that would be supported by the affidavit. So, do you think that's not a nitpick?
No.
This is so real.
This is a nitpick was probably a poor choice of words. I was just trying to explain that. Let's just leave that one alone.
Doesn't bother me.
What says the state?
Your Honor, in the affidavit, it says, based upon the investigation, the officer believes that there's probable cause that the defendant intentionally, willfully, and maliciously kicked the door open, causing damage valued at approximately $2,000, and then entering.
Yes, and that's why I like to, sometimes when I reread these or somebody else reads it, they see it. And yes, I would agree. I'd have to concede that it's written there.
Okay.
Doesn't mean that the person's guilty of it. It just means that there's probable cause for the charge.
Yes, ma'am. So, Mr. Punger,
Yes,
I
sir.
am going to find probable cause for the 2 charges. I'll set your bond. Let's see, they're both 3rd-degree felonies. The standard bond, sir. It looks like you have a little bit of history out of state. I'm not going to elevate your bonds. I'm just going to leave them where the standard would be. It's $5,000 per count. Have a great day, sir.
Thank you, Your Honor.
Yeah. Next up is Emilio Ramon Montiel. Did we do him? I thought we did. That name jumped out at me.
And Your Honor, Deborah Goins, PD's office. May I ask, I have Anthony Parton, which is a VOP. Has he been done?
He's the juvenile.
That's good for pointing that out. Okay.
Yeah.
But he was the first one you did.
Those first couple minutes, they come at you fast because everybody's wanting to be done first, and I'm juggling the juveniles and the people that are here in person and the privates and
Thank you,
interpreters. So those first 30 minutes are kind of stressful. But yes, you're right. It's the juvenile. Next up is Samuel Rivers. Mr. Rivers, you're charged with, it looks like it's a municipal ordinance. It is a municipal ordinance against soliciting in public. It says it's a third violation. So it's the Winter Haven Municipal Ordinance. Do you want me to appoint a court-appointed attorney for that?
Yes, sir.
All right, I'll go ahead and appoint someone like Ms. Cheatwood. I'm gonna make a note here so that gets done back in my office. Sir, I've looked over the Winter Haven PD affidavit and I find probable cause for the charge. Going to set your bond at $250. Have a great day, sir. Brandon Scaife is charged with domestic battery. Do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you, Mr. Scaife. I've looked over your affidavit, have it here in front of me.
So can I say something?
Well, like you said, I always try to discourage people from talking about the facts. I mean, some people have questions, but.
I understand, but sir, the only reason I came because the officer told me my kids are gonna go to DCL. So I chose to take the route to come. That's the only reason I came. Because I almost actually, I don't know who got the marks and everything on me. I just didn't want my son. My son's 11 months old. And I just didn't want him to go to DCL. So when the officer kept saying that over and over, it scared me, honestly. And I just say, all right. But I didn't do nothing, bro. I just did what he told me to do. So my kid wouldn't go to, my son is only 11 months old. I have the marks and everything on me, but they just didn't, you know what I mean?
Mr. Skate,
Yes, ma'am.
I'm with the Public Defender's Office.
Yes, ma'am.
Please don't say anything else
Yes, ma'am.
about this matter.
Yes, ma'am.
It
I'm
is
sorry,
not
ma'am.
in your best interest.
Yes, ma'am. I'm sorry, man. I'm just.
But
Yes,
that's
ma'am.
okay. I understand it's emotional, but as your lawyer, I'm just saying, don't talk about it right now.
Yes, ma'am.
Okay.
Mr. Scaife, I'll appoint the public defender. Looks like shows
Pre-vote, I think.
an FTA mandatory docketing. I don't even think I had that.
It's been
amended.
Yeah.
I was in jail, sir. I was supposed to go to court yesterday morning. I notified and I let them know that I had court, but I guess I wasn't on the docket, so they didn't take me out. But I was.
Do you know what the case is? 1404 is that? Yeah. So he. Yeah. When was that court date?
Yesterday, sir.
Yesterday. So you got arrested yesterday and you didn't.
No, I got arrested Tuesday, sir.
Okay.
Yeah, Tuesday.
Yeah. On the affidavit, it shows 4:28, about 4:15 in the afternoon. So you're right. And so if your court date was yesterday and you were in jail, you missed it. And then I don't even, do you have what did the judge do on the? There it is. Judge Patey was covering and did a no bond with a 5-day hearing. Okay.
Can it be just set on a new date for the hearing?
Well, handily, I was just thinking, let's see, he's out on a bond for a domestic battery and he's here for being charged with a domestic battery.
Right.
And he failed to appear yesterday, but he got arrested the day before. So handily, I think it's prudent of me to Parker him on the 1404.
No, man.
But Mr. Scaife, it's okay. Your remarks are not helpful.
Yes, ma'am.
Okay. But the fact is that he's currently has that case pending. Scaife. I don't have that on my sheet from the clerk's office. That's why, they list the ones that are Or there are other cases pending. I just didn't see that one.
You know, I didn't know about the second one being here at all because it didn't appear on my list.
Yeah.
But they typed it in because it must have got added late,
Mhm.
you know. But either way, whether I park him or not, he's going to be staying at least until the 5-day hearing,
Yes.
you know.
I take that. I take that. But I didn't. Listen. I'm
You
sure.
got a dog in the fight. Tell me what you want me to do.
Your Honor, state is requesting the defendant be parked on this case just based upon the facts of this case as well as the facts of the prior case being two similar charges.
Mr. Scaife, let's do it one at a time. I've looked over this most recent charge from Tuesday. It's finding probable cause, setting your bond at $2,500. If you post that bond, you must immediately check in with pretrial services. Call them on Thursdays, all the standard conditions, plus the following special conditions. Looks like your address is the same as the alleged victims, the best I can tell. So it's going to be 16, 17, and 18. No weapons or firearms, no intentional contact, stay 500 feet away from the victim, as well as her home and vehicles and where she works. 18 says you get to go back there one time to get your stuff, accompanied by the police within 48 hours of getting out of jail. I am going to find probable cause for the FTA. As much as I understand that you were where you were yesterday, I get it, I totally understand. But the other judge issued a capias, and I don't have a very much authority to tweak with that, to mess with it. So I'm going to, Judge Patey issued a capias with a 5-day hearing. We'll set you up for that 5-day hearing, probable cause, hold you no bond. And I am going to go ahead and hold you no bond pursuant to the authority of Parker versus State. Appoint the public defender if they're not already appointed on 26 MM 1404. But we'll send you to see Judge Patey or whoever's covering the M7 division on, it'll be Judge Kaler, so it'll be a 5-5. You'll go see Judge Kaler, and certainly
So-
y'all can discuss your bonds.
So will they? When I go 5-5, can they, like the Parker versus State? Can they look at that?
Yeah, I mean, that judge that's assigned to that division, in this case, Judge Kaler will be sitting in that chair. She has every right to give you a bond if she wants to. That's what the 5-day hearing is kind of to review it. Because the judge that, when you missed court yesterday, did a no bond, so they were going to review it for that purpose. Now they have every right, that judge does, to review what I did as far as the Parker. But again, be prepared to explain to her why she should do that, you and your attorney. All right, have a great day, sir.
Your Honor, Denver Gillespie Public Defender's Office. Just for Mr. Scape's information, I will contact the lawyer who has that case regarding what happened in court today. All right.
Have a good day, sir. Next up is Nidier Smith. Yeah. Mr.
Judge,
Smith, you
no.
have 4 separate charges that you failed to appear for. Looks like you already have regional counsel. I find probable cause because I'm looking at Judge Kaler's capias on the charge of resisting without. The bond is $3,000. On the charge of cannabis possession, $3,000. Paraphernalia possession, $3,000. And permitting an unauthorized driver to drive is $1,000. Add it all up, it's $10,000, cash or surety. Have a great day. Abel
Your Honor,
Strasburger, go ahead.
one question. When is my court date supposed to be? Because I was supposed to be going there and taking a plea deal.
May 27th is your next court date in front of Judge Kaler.
All right, thank you.
You bet. Abel Strasburger is charged with DUI. Mr. Strasburger, do you want me to appoint the public defender?
Yes.
Okay, I'll go ahead and provisionally appoint that office.
Okay.
Any, see, you're looking through it. Does he have any prior?
He does from 2001.
So, Mr. Strasburg, it looks like you have a prior DUI. Don't comment on it, but that's what I'm being made aware of in Highlands County in 2001. So I'll appoint the public defender. I have your affidavit from the sheriff right here in front of me. Going back to look over the specifics. It looks like there was no crash and they allege that your breath reading was a .089. So I'm going to find probable cause, going to set your bond at $2,000, going to make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up with them in person, calling them on Thursdays, all the standard conditions plus special conditions 13 and 14. While on pretrial, you cannot, while your case is pending, possess alcohol. You cannot drink alcohol. You cannot go to any bars, nightclubs, or lounges. You'll be subject to random urinalysis that tests you for alcohol. Have a good day, sir.
Okay, thank you.
That Charles Turnbull. Mr. Turnbull, you're charged with a warrantless VOP. What you're on probation for was petty theft and burglary. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint the public defender to represent you. I've looked over the Lake Wells affidavit, finding probable cause. It appears to be a curfew violation is what they're alleging. So I find probable cause, going to hold you no bond. We'll send you to see the circuit judge on May 26th. Johnny Turner has been charged with possession of cocaine, possession of paraphernalia, resisting without violence. Do you want the public defender?
Yes, sir.
I'll appoint him. I've looked over the Lake Wells affidavit right here in front of me, finding probable cause, setting your bond at $5,000 on the cocaine, $1,000 on the paraphernalia, $1,000 on the resisting without. Have a nice day.
Judge, can I say something?
Sure, just don't talk about your case, okay? It's probably just not a good idea to talk about your case.
So what's my bond altogether?
Oh, 7,000. All right, have a great day. Next up is Jonathan. I think we did Valentin, so never mind. Miguel, we did Miguel Vasquez Hernandez. I got moving fast and I didn't take out my paperwork. Yeah. So we're up to Darius Wiggins. Mr. Wiggins, you're charged with 2 violations of probation. They are for domestic battery and domestic felony battery. So 2 domestic felony batteries. Do you want the public defender?
I was arrested on Grand Theft Auto. I was on probation for domestic violence battery.
Correct. Yeah, that's what I always tell people, and it kind of confuses them sometimes. You're here for 2 cases.
Oh, okay.
Each one of the it looks like it's a 7638. It's felony battery and felony battery by strangulation, to be specific. So it's 2 charges within that case, count 1 and count 2. As far as what caused you to violate, you're right. Violation 5, they allege that you committed a grand theft motor vehicle in Polk County on April the 26th. So do you want a public defender?
Yes, please.
Previously appointed.
Based off of his standard, I believe.
I ask out of habit, and then I look over
Yes,
there and
please.
see. But so you already have the public defender, finding probable cause based upon this warrant. The judge wants you held no bond, which you probably already were held no bond. You'll go see the judge on June the 2nd. Have a great day. Malik Williams is charged with violating his probation. What put him on probation was dealing in stolen property. Do you want the public defender?
Yes, Your Honor.
I'll appoint the public defender. I'm looking at Judge Harb's warrant. He signed it the 24th of this month. There's looks like 3 or 4 different allegations. Finding probable cause, setting your bond at a no bond. We'll send you to see him on May the 26th. Have a great day, sir.
All right, thank you, Your Honor.
You bet.
Oh.
You bet.
You know what time it is on May 26th?
8:30.
All right, thank you, Your Honor.
You bet. Richard Charles Williamson is charged with domestic battery. Do you want the public defender?
Yes, Your Honor.
I'll appoint the public defender. Looked over the Haines City Police Department affidavit, finding probable cause, setting your bond at $2,500, making it a condition of pretrial release. If you post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Thursdays, all the standard conditions, plus special conditions 16 and 17, which says you can't use or possess weapons or firearms or ammunition, and you can't have any intentional contact with the victim. Stay 500 feet away from the victim, their home, their vehicles, where they work or where they go to school. Have a great day, sir.
Okay, thank you, Your Honor.
And real quick, I see that you live allegedly in Detroit, Michigan. I
Yes.
assume if you bond out, are you wanting to go back to Michigan while your case is pending, or are you planning on staying here?
I haven't made the decision yet.
Okay, like I said, just so you know, a standard condition of pretrial is you can't leave the state of Florida. So if you weren't planning on leaving anyway, then no harm, no foul. But if you're saying, Judge, I live in Michigan, I was gonna bond out, knowing I gotta come back when I'm needed, but I was gonna go back to Michigan, then certainly we can discuss it.
Okay, yeah. What would be the terms if I was to go back home? Would I be able to do virtual?
Well, potentially that's up to the judge that you're assigned to. But at some point, whether you have a trial or whether you enter a plea, you would need to be physically here. Anything short of the state dropping the charge, at some point you would have to come back here.
Okay, that would be fine, Judge.
So are you planning on staying around? Or are you planning on going back to Michigan?
I plan on going back home.
Okay, so let's do this. We'll delete condition 10. So I'll allow you to, return to Michigan. But just know you bond out. That's what bond's for, is to make sure you come back. And if you don't bond out, then of course there's gonna be a warrant. And that's all bad news. So, all right, have a good day, sir.
Thank you, Judge.
That's between the judge, him and the judge that is assigned. All right, and I think we're up to Hollis Wilson.
Yes, sir.
Mr. Wilson, you're charged with 5 crimes. They are tampering with physical evidence, resisting without violence, possession of cannabis known as marijuana, possession of drug paraphernalia, and fleeing or attempting to elude a police officer with lights and sirens activated. Do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you. I've looked over the sheriff's affidavit. There is probable cause. Going to set your bond at $5,000 on the tampering, $5,000 on the fleeing to elude. The remaining 3 misdemeanors will have $1,000 per count.
What's
Add it all up,
tampering?
it's
What's tampering?
$13,000. You're saying what is tampering?
Yes, sir.
Well, they're saying that you tried to discard the drugs that you had.
I ain't had no drugs.
Don't talk about it. I'm just trying to answer your question.
Oh,
They said
okay.
the policeman tried to stop you on your bicycle. You fled from him, went behind a building and discarded your drugs in an effort to conceal them from him. So that's the tampering. Have a good day, sir.
Thank you.
Yeah. All right, and with that, I think we're done. Deputy Fletcher, thank you for all your help today.
Yes, sir.
Y'all have a great one.
I started the hearing, I wanted to lay out where we've been.
Good morning, I'm hearing examiner Meister, take April 30th, 2026. Can the board members please state your names for the record?
Robert Sisowskis.
Panel Member Barry.
Mike Polk.
This is a final revocation review for Bell Lyman number 308351. I recommend a revoke with a repro date of 4/30/2026 with the following conditions: halfway health placement, mental health evaluation, near management program for anger management, no contact with co-defendants Eric Teal, Don Godchild, and Kevin Persate, and no contact with victims EF, TM, TR, DH, MH, and TC. Does the board accept the recommendation?
Panelmember Berry, do you
I accept.
accept? Okay, so I'm going to move to adopt the hearing examiner's recommendation. Do I have a second?
Second.
All in favor? Aye. Motion carries by unanimous decision.
This includes finding for Bell, number 308351. Good morning, hearing examiner Meister, case April 30th, 2026. Can the board members please state your names for the record?
Robert Sisowskis.
Panel Member Barry.
Mike Polk.
This is the final revocation review for Green Leon number 266472. I recommend a revoke with a repro date of 7/28/2026 with the following conditions: no consumption of alcoholic beverages, operation of motor vehicle, and the management program for domestic violence. Does the board accept or reject recommendation?
Accept. I accept.
I accept, but, the only, I wanted to add a halfway house just in case it's needed because the sponsor he listed was the grandmother of his children and just in case that.
Yeah.
uh,
Okay with that? Yeah, that's fine. Okay. So, I'm going to move that we adopt the hearing examiner's recommendation with the addition of a halfway house stipulation. Do I have a second? All in favor? Aye.
This includes time due for Green 266472. Good morning, I'm hearing examiner Meister. Today's April 30th, 2026. Can the board members please state your names for the record?
Robert Sisowskis.
Panel Member Barry.
Mike Polk.
This is a final revocation due for Hannes Tyshawn, number 366531. I recommend a revoke with the date of August 12th, 2026 with the following conditions: mental health evaluation treatment deemed necessary, no contact with co-defendants Eric Gomez, behavior management program for domestic violence, and a general no contact with DD and JC. Board accept or reject the recommendation?
Accept. Panelmember Berry.
Accept.
And I also accept. I move to adopt a hearing examiner's recommendation. Do I have a second? All in favor? Motion carries by unanimous decision.
This includes final review for Hannes, number 366531. Good morning, hearing examiner Meister, case April 30th, 2026. Can the board members please state your names for record?
Robert Sisowskis.
Panel Member Barry.
Mike Polk.
This is the final revocation review for St. John Travis, 230562. I recommend a revoke with a revoke date of May 5th, 2026 with the following conditions: halfway house placement, no consumption of alcoholic beverages, operation of a motor vehicle, no contact with co-defendant Patrick Tassani Jr., no contact with victim RB, mental health evaluation and treatment deemed necessary, and a general no contact with 7-Eleven at 253 Main Street in Manchester and Extra Mart Convenience Store, 95 Buckland Street, Manchester, Connecticut. Does the board accept or reject this recommendation?
Panelmember Berry.
Accept.
And I also accept. I move to adopt the hearing examiner's recommendation. Do I have a second?
Second.
All in favor?
Aye.
Motion carries by unanimous decision.
This includes final review for St. John, number 230562. Good morning, my name is Paulson Meister, today's April 30th, 2026, and this is a case review, Connecticut Board of Pardons and Paroles. Can the board members please state your names for the record?
Robert Sisowskis.
Panel Member Barry.
Mike Polk.
Case review is being conducted as PCS is requesting that the halfway house placement condition be added for inmate Kareem Abdul Mayo, number 210552. Has the board reached decision?
Any objection?
No.
In regards to Kareem Mayo, inmate number 210552, I'm going to make a motion to add a halfway house placement to his current stipulation. So I have a second.
Second.
All in favor?
Aye.
This includes the case review for inmate Kareem Mayo, 210552. Good morning, my name is Paulson Meister, case April 30th, 2026. This is the case review of Connecticut Board of Pardons and Paroles. Can the board members please state your names for the record?
Robert Sisowskis.
Panel Member Barry.
Mike Polk.
This case review is being conducted as PCS is requesting that a no contact with victim KS be added for the Neely Nino, number 373601. Has the board reached decision?
Any objection to this?
Nope.
Okay. In regard to Nino Neely, inmate number 373601, I'm going to make a motion to add no contact with victim KS to his current stipulations. So I have a second. All in favor? Aye.
This includes the case review for McNeely, 373601. Good morning, my name is Officer Mike, April 30th, 2026. This is a case review of County Board Pardons and Paroles. Can the board members please state your names for the record?
Robert Stazauskas.
Councilmember Berry.
This case review is being conducted as PCS is requesting that the halfway house placement condition be added for being Vargas Jaquan, number 34730. Has the board reached?
So in this case, I noticed that 2 days ago, he was approved for a sponsor and has moved into the house, no longer need the halfway house. So
It's added just in case.
he's living in the house already.
Right. How much time does he have left?
EOS 11427.
Oh, okay. Well,
Yeah, and he's living at the house. They've approved it. They've done the walkthrough and it was on the 28th that he was actually in a halfway house when they submitted this. He's been released from that and is living in a private sponsor's home. So I think on this one, we take no action. We need to make a motion for that?
yeah.
All right. So I'm going to make a motion in regards to Jaquan Vargas, inmate number 347230, that we take no action on this recommendation. Do I have a second?
Second.
All in favor? Aye.
Case review for Vargas, number 347.
So,
Good morning. I am hearing examiner Bernard. Today is Thursday, April 30th, 2026. Board members, please state your names for the record.
Robert Stazauskas.
Councilmember Berry.
Mike.
This is a final revocation review for Michael Jimenez, 1825. I recommend a revoke and be parole date of December 1st, 2026, which is approximately 12-month sanction with the following conditions. Halfway house placement, general no contact with Famous Footwear. Address is 224 Newbury 9th, Plainville, Connecticut. And no contact with James without his permission. Mental health evaluation and no operation of vehicle without PO's permission. Does the board accept or reject this recommendation?
So, Mr. Chairman,
Yes.
so in reading this, and I appreciate recommendation and such, but the obedience to law, this offender, their last offense involved driving a motor vehicle without a license and such. This guy was on a bicycle that didn't have the right reflectors or lights, which started the whole piece of stopping him and thus finding the drugs on him and stuff like that. He was homeless and such. And while I understand why the 1 year recommendation was made, I would actually support a lesser sanction on this case.
Yeah, one of the things, I feel the same way. One of the things that I looked at was that his end of special parole is on May 5th, 2027. And given his struggles with housing and substance abuse, I think a little bit more time in the community might help him get the kind of structure and support he needs before he's out on his own, Instead of 5 months, we could make that period of supervision a little bit longer. Councilmember Berry, where were you on?
I accepted the hearing examiner's recommendation. This is his third parole violation. He was out for just a few months when he received this conviction, and he's had 9 failed releases, and this is his second new conviction since he has been out in the community. So I will vote on the minority, and I understand why you all would think that a lesser sanction is warranted here.
Where was he actually convicted of any of these? These are all now.
Right, but there's still okay, let me change the wording.
Yeah.
Maybe not conviction, but new arrest or new charges.
Yeah, I would, certainly inappropriate behavior for certain, absconding and, GPS violations reporting. And what he did there with the police certainly inappropriate. But I do think that there could be some benefit. Let's talk about where we're looking at time.
Based upon what's happened here, and just the amount of time that he was away and then he was battling with homelessness and such. His end of sentence is May of 27. A 6 month sanction would give him 11 months, at least in a halfway house.
Yeah.
If, to get some kind of support there. I just don't want to set him up to absolutely fail.
Yeah, he's gonna need the support. Looking at his record, there's been an addiction problem for a substance abuse problem for a long time.
In the homelessness piece, they've been giving him a halfway house, and he pleaded. There's nothing.
If he goes out in 6 months and he can't do what we're saying, that he's gonna be back, right? We're gonna have the same kind of behavior. All right, so December 1st backwards 6 months would be June 1st.
What day is that on? Also,
Let's check that day of the week. Yeah, let's just make sure that that day of the week is not a weekend.
It's a Monday.
Okay, so we should be okay with that, right? Okay, so let's try to get through this motion here. We have reviewed the findings and recommendations and rejected recommendations in favor of a lesser sanction. I move that Mr. Jimenez serve a 6 month sanction with the conditions as stated by the parole officer.
You need to state a release date, Officer Chair.
And then I further move that we reinstate his special parole on June 1st, 2026. Do I have a second? Second. All in favor? Aye. Opposed?
Nay.
The motion carries by majority decision.
This includes the final revocation review of minutes Morning, I am hearing Examiner Menard. Today is Thursday, April 30th, 2026. Board members, please state your name for the record.
Robert Sizowskis.
Councilmember Berry.
Mike Polk.
This is a final revocation review for Robert Kennebrew and make number 200299. I recommend a revoke parole date of August 24th, 2027, which is an approximate extension of the following conditions. Halfway house placement, no contact with co-defendant, Marcus Petaway or Philip Harris, no contact with victims, JN, ET, and AC. General no contact with my eye doctor at 604 Lakewood Road, Waterbury, Connecticut. Does the board accept or reject this recommendation?
I accept.
Accept.
Okay. I move to adopt the hearing examiner's recommendation. Do I have a second? All in favor? Aye. The motion carries by unanimous decision.
This concludes the final revocation review for Robert Kennebrew and May number 200299. Hearing Examiner Menard. Today is Thursday, April 30th, 2026. Board members, please state your names for the record.
Robert Sizowskis.
Councilmember Berry.
Mike Polk.
This is a final revocation review for Calvin Rodriguez, number 367222. I recommend a revoke and re-parole date of December 23rd, 2026, which is an approximate 10-month sanction from the day he was returned from Connecticut custody with the following conditions: halfway house placement, behavioral management program, management, mental health evaluation, no operation of motor vehicle without parole officer's permission, and general no contact with Carrie Privatera and Luis Calvo. Board accept and reject the recommendation.
Councilmember Berry.
Accept.
I also accept. Okay, I move to adopt the hearing examiner's recommendation. Do I have a second?
Second.
All in favor? Aye. Opposed? None. Motion carries by unanimous decision.
Nation. This. 367. Anytime with a serious. Nice.
My name is Sue Nelson. How are you?
Good morning, how are you? How about yourself?
Good. So we're just gonna get the board members here who were there last week when they made the decision, and I'm gonna go find your attorney, okay? And then we'll get started.
Okay, thank you.
Thank you. Just so you're aware, you're live streamed, okay? So just be mindful of that, all right?
Okay.
So good morning, my name is Paul Officer Trisella, and today is Thursday, April 30th, 2026. I'm a hearing examiner for the Connecticut Board of Pardons and Paroles, and this is a supplemental hearing concerning George Nelson, inmate number 414045. This is a public hearing, and public access to this hearing is available via video live stream. Board members, can you please state your names for the record?
Light pole.
Aileen Keys.
Member Rodriguez.
So this hearing is being conducted because the panel identified issues that can justify confinement beyond what was recommended at the board review on April 23rd, 2026. Mr. Nelson, can you please state your full name and inmate number for the record?
George Nelson. Good morning, George Nelson, 414045.
Thank you. And also present is your attorney. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sirica with the Parole Revocation Unit. Mr. Nelson, if I may, the video feed sometimes goes in and out. If at some point it's breaking up, just raise your hand. There's no way of me knowing if you're hearing what I'm saying or what any of the board members are saying, okay?
Okay, no problem.
So Mr. Nelson, you have certain rights that apply to this supplemental hearing. The first is that you have the right to receive the written notice of the supplemental hearing. Did you receive a packet of information which would have included the written notice of the hearing and the reason for the hearing to be conducted?
Mhm.
Did you say
Yes.
yes?
Yes.
Thank you. You also have the right to be represented by an attorney, and counsel is here present for you. You also have the right to submit relevant documents, evidence to address the issues or issues that the panel determined may justify confinement beyond what I had recommended for revocation hearing. So counsel, do you have any documents that you want to submit today?
It's gonna be strictly verbal testimony.
And you also do have the right to call witnesses to testify on your own behalf and cross-examine adverse witnesses regarding the issues that the panel determined. So counsel, any?
No.
So Mr. Nelson, do you have any questions before we begin?
No, ma'am.
So the testimony at today's hearing will be taken under oath. So Mr. Nelson, can you please raise your right hand? Do you solemnly swear? Can you hear me?
Yeah, it was just going in and
His
out.
hand
for a
was
second.
going back.
I can hear it though.
You're good? Okay.
Did you actually
you
just
solemn-
right here?
Yes, please.
Okay.
So do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth,
Yes.
and nothing but the truth, so help you God or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're gonna, so during this hearing, or during your hearing, I did find that you violated the condition of obedience to the law and recommended a sanction of 4 months of confinement. The panel did determine that the information in your record could justify a departure beyond my recommendation. So at this time, it is the defense's opportunity to respond to these concerns. Counsel?
Yes, if I may. First, I'd like to address, I believe, the hearing examiner indicated 4 months. Mr. Poe, I watched this hearing numerous times. Initially, you indicated it was a 3-month sanction, but then along the way, the first time around, you did correct it. But I just want to make sure we're on the same page that we started. That all the documents indicate 4 months, but verbally it was stated it was 3 months. Yes, it's 4 months. And regarding this particular file, so Mr. Nelson's file, I think the word I have down is quirky from day one. And what I mean by that was that the PCS addendum was not filed within the 14 business day regulation that's in place. But the problem with that regulation, there's no remedy if that addendum is late. So to start with, the addendum was late, which meant my client didn't get his revocation hearing within the time frame in the regulation. And then obviously I received all the evidence, and once I saw the disposition with an infraction, I did not anticipate being in front of a 3-member panel for the infraction on criminal charges. I understand from what I heard you say on the record and your colleagues agree to it, that you have some concern regarding the potential escalation of violence or something along those lines, which you indicated on the record. I just want to put on the record, this is my client's, it's his first parole violation. In my humble opinion, the 4-month sanction on an infraction is more than sufficient punishment for an infraction. Now, with the understanding, and I'll get into that regarding the police report, my client does not have any domestic convictions on his record from what I've gathered and what I found through my investigation and criminal background check. And I'm gonna address the New York issue shortly, but I do want to address these particular facts because in my opinion, it is very important. The argument, according to the police report, was over my client coming home late and the victim wanted him out and she wanted to change the locks. also states in the police report that she was the only one on the lease. That is absolutely not true. I do have a copy of the lease, residential lease agreement, and made on the 7th day of May between the properties, both parties named are on the lease. What my client should have done before the verbal dispute occurred, he could have called the police. We do have a statute in Connecticut, criminal lockout. His name's on the lease. He doesn't have to leave. He did leave. He went outside, and when the police came, he was smoking a cigarette outside the apartment. He never left. He never left the immediate vicinity. I understand what is written in the police report, but the police report is strictly hearsay evidence, and I'm not well aware. The panel is aware how criminal trials work. The police are called. The police investigate, police talk to people, police write a police report, they submit it to court, and a prosecutor and judge looks at it. That's how we come to a disposition. My client from day one maintained it was a verbal dispute, and he indicated I was outside smoking a cigarette. If that had occurred, obviously I would have ran. I would have taken off. I'm not going to wait out there if that's what occurred. He tells me that, and I says, I'm sorry, I represent you on the parole violation part. That's going to have to be dealt with in court, which it was. Now, when he went to court, he had an attorney there. He advised his attorney what occurred. Now, the prosecutor, they did their investigation, obviously, and the charges went from those criminal charges. It could have easily been a suspended sentence on a breach of peace, disorderly conduct. There's numerous other charges that the prosecutor could have held my client responsible for, but to get from those charges on paper, they just on paper to an infraction tells me a lot. Spent over 18 years in the criminal court before coming to this unit almost 7 years ago. There was some issues with elements of the charge. He said, she said. I understand what the police report indicated regarding some marks and things of that nature. I did not receive, I'm not sure the panel, any pictures of any type of injuries. There's none of that in evidence. None of it was presented in court. And my understanding was the victim did submit a letter to the victim's advocate, which made its way to my client's attorney, the judge, and the prosecutor. And once again, in criminal charges are brought at a plea, the prosecutor has to put the elements of the crime on the record, and the judge needs to make a factual basis of that. And the transcript I received from the day of the sentencing, this is Attorney Holly, who's the prosecutor. Your Honor, December 20th, 2025, police dispatched to an address here in the city of Waterbury on a verbal document which dispatch relayed to the officers that the complainant had told her to leave the house. He refused to do so. They arrived. They located the defendant smoking outside the residence. When they questioned him, he said that he and his girlfriend were arguing because he did not come home last night. And when he did, she was upset and told him to leave. So, excuse me. The factual basis that the prosecutor put on the record has to be accepted by a criminal court judge, which the judge did. And the other point I want to make is in the hearsay police report, thankfully, in my client's case, we have a prosecutor who does the checks and balances, who's credible, what's credible, what evidence can come in, not come in. And that's what the prosecutor put on the record regarding the facts, the factual basis, and the judge accepted those factual basis on the record. As far as my client, when he got back from New York, once again, I'm saving that part for the end, he did immediately get a job with Turkey Hut, which is a family-run food truck, and he'd been working with that family business for 2.5 years. He already started a little side business, landscape in New Britain. So he had 2 jobs. He did attend 12 sessions of anger management of April of 25 to May of 2025 at MCCA, which is the Midwestern Connecticut Council of Alcoholism, but they also do anger management. And he's also previously done outpatient behavioral health treatment in the past. There was no issues with his, he had a previous parole officer, I believe he indicated to me it was Peel Descent. He said a great relationship with parole officer and had spoken about potential violent paperwork for early termination. He was in compliance with what we were supposed to do. Regarding, I believe that was your main concern, Mr. Poe, the New York incident. You indicated he came back and you want to know what that was about. After speaking to my client, I believe the charge in New York was brandishing a firearm, which was not a violent offense, not considered a violent offense. He did not use that in the commission of any type of crime. The allegation was that my client, someone saw him with a firearm, and in the course of the investigation, my client was leaving a restaurant and he was picked up by the police in New York as he was leaving a restaurant. He was held, obviously. They did their investigation, and ultimately it was time served on that sentence for him to come to back to Connecticut to start his supervision here in Connecticut. So I just want to make it abundantly clear. I understand it was concerning regarding the domestic violence. It's nothing like this at all in New York. There was no violence in New York involved. There was no gun was ever found in New York. I just want to make sure that the record is abundantly clear regarding that. And I'm sure you're going to have some questions from my client regarding that. But those are my initial comments, kind of give you my take on the overall facts and what occurred in court and what the ultimate disposition here was in court for my client. Thank you.
Thank you. Now, we'll proceed to questions.
Sure.
Okay.
What is okay? Do you want to make a statement? Do you want to make a statement?
Do
you want to hear?
you have anything further to add from your, what your attorney said?
No, I just, wish to get out and continue doing what I was doing, as far as working and taking care of the kids and stuff like that. And, I'm very sorry that this happened or whatever, but, I'm trying to better myself and just move on from the situation. And, I would just ask to take y'all, if y'all can consider it, though it has been, 3 years that I've done straight with no incidents, no complaints, no nothing. I was just, out there doing what I had to do. And, anytime I wanted to do something or whatever, I went to them and I asked for permission like I was supposed to. Even when I got arrested, I called him like I was supposed to and let him know the situation. And I got called back 2 or 3 times. And in the transcript that he said was that I told him that I was at the house with my fiance, and that wasn't the case. I was at my mother's house. So I don't know where he got that from. And I wish there was video or some type of voice that was active or whatever, because I never said that to him. You know what I'm saying? So, and I understand that when you catch a charge or whatever, they could be, remanded. But at the same time, I never had no issues with parole. Never. So I don't understand why he said that at all. Because even if he would have asked me that question, I would have told him I'm at my mother's house. My mother has cameras. That shows that I was there. So I'm not understanding where he got that from at all. But I'm just asking to take consideration to let me back out there so I can take care of my family and do what I got to do.
And if I may also, Mr. Poe, I advised my client you were going to have, the panel was going to have questions for him. That's why I think Mr. Rodriguez indicated a statement.
Yeah.
My understanding of this, there's going to be some questions.
Sure, certainly. And there will.
I still wanted to hear from you.
Yes.
I looked at his last interview and I had saying I didn't want to hear.
Fair enough.
Thank you.
So I just want to establish a couple of things. Why are you on special parole right now?
I'm on special parole for assault first.
And in that assault first, or assault first, 1 or 2 counts?
2 counts.
And in those two in those 2 assault first, what did you do?
I was actually robbed. So at gunpoint, you know what I mean? So I actually took, after I had a gun pointed on me, I took it in my own hands and defended myself. I can't.
Okay, and what did you do? Because I want to get to the basis of what my concerns are, and we'll get to the
I end up
other board members.
shooting the victim that had a gun pointed to me that robbed me for $3,000.
Okay, so you had a gun and you shot someone,
Yes.
right? And then the other assault one, which was on a different date, right?
Yes, but the only reason, yes, you're absolutely right.
Then the other assault one was what?
That I did, that was, they wanted to run the cases together. So I felt like that if I went to a jury on that, that I would probably, it wouldn't, you know what I'm saying, it would be a 50-50 chance. So I didn't do it, is what I'm trying to say to you.
Okay.
I never did that.
Right, but I'm trying to get you to understand why we're here today. And the second conviction that you're on special parole for right now, what did you plead guilty to?
I pled guilty to everything at once. That's what I'm trying to tell you. It was assault versus. It was assault versus.
Both assault first, and
Yes.
both times people were either shot or shot at, right?
Yes, but the first one is the one that I did.
Okay.
You know, the other charge came a little bit later, and that dude just put that they was best friends, and he just told him I did it. That's what I'm trying to say. I'm taking ownership of the first one that I did, is what I'm saying to you.
Okay. Now, we talked about, we broached the subject with New York. That's something that happened on discretionary parole, which is something that, that was over and done with, and now you're on special parole, right? But in that case, in New York, what were you actually charged with?
It was brandishing a firearm, I believe.
Brandishing a firearm.
Yes.
Or to get to be more specific, it was criminal possession of a weapon, second loaded firearm.
Yeah, but I never had a firearm, but they offered me time served. It was like 18 months or something like that. So I didn't want to go through the trial process, so I just pleaded guilty to it.
Okay, so criminal possession of a loaded firearm.
Yes.
And that's what you did time for in New York?
Yes.
And then you came back to Connecticut to begin special parole.
Yes, because I successfully finished my parole and everything when I was on house arrest out there and everything, and I successfully finished everything. And then I told them that I wanted to come back so I can finish up my time here.
Okay. And then, just, have you had other weapons charges in your criminal history?
No.
No other weapons charges?
No.
Okay. And part of the narrative in the police report that was part of the evidence that was presented during the revocation hearing, you were accused of what?
I guess putting my hands on my wife. So it was a domestic violence.
So, and not convicted of, and your attorney's explanations in the record. However, you were charged with strangulation second.
Yes.
Okay. So, do you understand why we're here?
Yes. Absolutely.
Okay. So that just to establish the groundwork of why we're here, right?
Mm-hmm. Yes.
Because for me, it's like, if we weren't here right now, I would be negligent in my duty, right?
Mm-hmm.
Based upon everything that's there, right? So now that we have that established, I want to find out if other board members have questions in regard to this case.
Yes.
Board member Keys, questions?
Thank you, yes. Thank you, Mr. Nelson, for answering everyone's questions so far, my colleagues' questions so far. I do have some additional ones, but your answers so far have been helpful. I just want to make sure that when you signed your conditions of parole, you are aware that if you violated parole, then you could be remanded to serve until your end of sentence, which for you is March 15, 2031.
Yes.
Okay. So sometimes people say they're not aware of that, so I just want to make sure that, you know, in the beginning that you're aware of that. I'm sure your attorney has been very thorough, and I'm sure he had told you too, but I just wanted to make sure. So when you were discharged of special parole, so this New York offense, you're saying that you didn't have a gun and you never shot a gun, right?
No. I didn't. What I'm saying is I was accused of having a gun. I never had a gun. Someone told them, I guess, that I had a gun or whatever. But I was coming out of a restaurant and they ran down on me from a restaurant. They didn't find any gun. I didn't have any gun or whatever the case may be. But I've been sitting in the county jail for some time. So when they came with the offer, I just took the offer and I wanted it to be over with.
Yeah, I understand accepting it, especially if you've been sitting there that long. So,
My fiance was pregnant with twins. You know what I'm saying? She lost her twins from the police having a whole bunch of stuff in the precinct trying to get her to tell on something that didn't happen. You know what I mean? So she bled out right there in the precinct. They didn't take her to the hospital or anything. And just for the record, the same officer, the supervisor that did all that, he just got charged with something in New York.
So in the police report from New York, and I understand the attorneys, putting into context police reports, but it does talk about video camera footage of what they identified to be was having a gun, and then you and your fiance in the subsequent interviews, both acknowledged having a gun. After at first denying it, it says that you both did acknowledge that you had a gun.
No, but like I just said, that same officer, he just got criminal charges for setting people up in New York.
And it says that the video of your interviews were uploaded to, and then they give the website. So there would be video of that interview where reportedly.
I seen the video, and that's why they came down on the charges and gave me time served, because it didn't show that I had a gun. That's exactly why.
And the video footage that they're saying showed you having a gun, you're saying that footage was also?
That's the footage that I'm saying, that it didn't show me as having a gun. So when I went in there, I was going to go to trial on that because I know that I didn't have no gun. But they offered me time served right then and there. It was like 15 months, 18 months or something like that. And I just said, I'll take it just to get it over with.
And then the plea you took, that was for, because the original charges were the criminal possession of a weapon second and reckless endangerment first. But the plea you took was for what conviction with time served?
I'm not even sure. I don't want to tell you something that's not correct.
That's smart. I appreciate that's smart. That's very good. I don't.
They use different statutes in Connecticut.
In
New York, and I'm not familiar
with what it is.
That's why I didn't want to put anything on the record. I'm not licensed in New York, so I can't speak on what the actual statute.
So all we have is reports that we have.
Correct.
That's what we got to go with.
Yeah. Thank you. I appreciate your intent to be fully honest and not misrepresent anything. So you had answered my colleague and said that you don't have any prior history with gun convictions, right?
Excuse me.
Yeah.
Unless you're talking about like from 2025 with the North Carolina and Virginia situation. But I'm talking about as far as me being on parole or anything like that. No, I haven't.
Okay, I appreciate the clarification because that seemed like a misrepresentation of the truth. And so I just wanted to, because there have been other things, but that's not what we're discussing today. But I just wanted to make sure that you weren't saying that there was nothing ever. Okay. And I understand what you're saying about the two assault bursts that you're saying you did shoot the one person, but you did not shoot the other. And you're saying it was self-defense. He was in a car, right? But you're saying you were outside the car.
Mm-hmm.
But you're saying that he had a gun and that you shot into the car at him because of that?
No, what it was is I was robbed a few hours prior to that. And then, when I seen him again, I mean, it just escalated from there.
Yeah. And some prior interviews, you talked about, you realize you should have called the police or something, but instead it was like the kind of the street
Absolutely.
justice, which is what you kind of say is a culture you had known at that time. And I don't mean to put words in your
Absolutely,
mouth.
absolutely. I mean, at the same time, I paid the price. I paid the price for, what I did. And, I mean, I'm sorry that happened, whatever case, but I paid for that time,
So, all right, so when you came back to New York, let's see, I think you came back January in 2025, after being in community supervision in New York, if I'm correct. How were you getting along with your parole officer then? How were you doing then? If you could tell us about how you're doing on special parole.
I was doing excellent. I was planning on getting off of parole altogether. She told me to give her another year and that, I was doing excellent. She actually moved off my case because she was something like a supervisor or whatever. And she was like, I don't even want to stay on your case anymore. You're doing good. I just want you to keep doing what you're doing so I can get you removed from here. And I was like, okay. But the issue with my parole officer was I asked him for a pass to go to New York for Thanksgiving. And he wanted to deny me a pass to go to New York for Thanksgiving. So I asked to speak to the supervisor because I had no problems, So the supervisor said, the man just came out of the country. He's been like everywhere he wants to go. He asked for passes with no problem. Ahead of time, on time, everything. There's no reason why you should tell him that he can't go on a pass to Thanksgiving for his family. Mm-hmm. So he offered me he issued me a pass. Ever since then, me and my parole officer just been like not seeing eye to eye. Okay. And I tried to come to him and speak to him as a man. Like, listen, like, I don't want no issues. I don't have no issues with you. Whatever you want me to do, you offer me classes, whatever. I'm trying to do what I have to do. My daughter just had my grandkids. You know what I mean? I'm a granddad now. I'm trying to be a changed person. I'm trying to do what I have to do. I understand situations happen. I'm not perfect. But at the same time, the only thing I can do is try.
If I may,
yes,
I did explain to my client, he had issues with his parole officer, currently was violated, but the sole basis was the incident that occurred which resulted in creating a public disturbance. So I did explain to my client, once there police involvement, even if his parole officer didn't want to violate him, the supervisor is gonna make him file the remand paper. So Mr. Nelson is aware that, although frustrated the current, but that seems to be an ongoing issue. But he indicated he had a great relationship with his first parole officer, and they spoke about getting off the parole earlier, and he needed to behave for another year. Obviously, this incident occurred.
Right.
Actually, excuse me, I'm sorry. Okay. I mean, not to cut you off, but my probation officer, at the same time, when parole wasn't trying to let me go on my pass, my probation officer and my parole officer had an argument because my probation officer was trying to figure out why he was trying to deny me. He had me call my probation to get paperwork and everything sent over when he couldn't did that himself or whatever the case may be. But I did it myself. I called her. I said, listen, can you contact my parole officer? They got into an argument over there because she didn't know what was the problem. It's been like an ongoing problem with me and my parole officer ever since that day.
And so that would be is that Thanksgiving 2025 then? Because you came back from New York January 2025, so that'd be. So you had, I'd see 4 misconducts though before Thanksgiving.
4 misconducts?
4 misconducts were issued before Thanksgiving?
Yes, that was when my wife, she was going through problems with the babies or whatever, and I was at the hospital, and the person that worked at the halfway house, I guess that was his second job. So when I left work to go to see what's going on with my fiance, he worked at the hospital. So when he came to me, he was very what are you doing here? You're not supposed to be here. I said, I have a family issue. I called them and told them that I have a family issue. My wife is in the hospital, and I would like to go to the hospital. So they told me, call back, just wait for our call, whatever the case may be. And I waited to the point where, you know, I couldn't wait anymore. And I just went to the hospital and he was there and he came, you know what I'm saying? He was yelling at me in the hospital. So my anger got the best of me at that time. And, you know, I was just let him know, listen, my wife is right here laying in the hospital bed. You know, what do you want me to do? She can die. You know? I called the halfway house. I did everything I was supposed to do.
So did you call the halfway house before you went to the hospital?
Yes.
Because that was not reflected, and it sounded as though, you know, the PO saw you and then went and he called the halfway house. They said they did not know you were at the hospital, that you had signed a pass to go to work.
That was not the PO. That wasn't the PO. That was I think he was like he just worked at the halfway house. It wasn't the parole officer at all.
Oh.
He just worked at the halfway house and he seen me there and that's when he just came at me crazy and, you know, that was that right there.
Okay. So you're saying that the guy who was working part-time at the hospital who saw you there, that him saying he called the halfway house then to make sure they were aware you were at the hospital and they said they were not aware. You're saying that's not true?
No, what I'm saying is I don't know if he didn't call anybody. When he seen me, what are you doing? You're not supposed to be here. This is his second job. The nurses and the doctors gave me their phone numbers and everything and said, listen, if you need us for anything, please contact us. Like he's not even supposed to be, you know, coming at you like this. This is not the halfway house. This is a hospital. You know what I'm saying? And they was even wondering why he even was approaching me like that. And I told them, I said, listen, I'm in the halfway house right now. He works in the halfway house as a second job. I'm just trying to tend to my wife and see what's going on, you know, and go back to the halfway house. I called them. I did everything I was supposed to do. I can't just leave my wife laying in the hospital bed by herself like that, you know?
I see what you're saying. That does sound like an unfortunate situation, but I think that, when did you finish anger management? Do you remember?
I don't know the dates, but I know I did anger management like 2 or 3 times and I finished it successfully. I went every week. You know, I took every drug test. I took every test they wanted me to take. I did everything I had to do.
Okay. Till May 2025. But 12 seconds. But you're saying you took it before that too, as well.
Yes.
So, right, so
Yes.
that'd be May 2025. So this incident at the hospital was March 2025. And then 2 of your other misconducts were for GPS shutdowns. I'm not as concerned about that. I mean, that you are advised to charge it and everything. And they do sound like they were in the middle of the night. So I'm not personally focusing much on that. Then the other misconduct was July 4th. 2025. So this would be soon after you completed anger management. And that was, the misconduct was for violent behavior and police were called because you punched a hole in your sister's drywall. Police did come, but you weren't arrested because I guess your sister chose not to press charges, but you still received the misconduct because the behavior that had exhibited. So do you know
Yes.
why? And then of course we have, so that was July 4th, and then we have the arrest in December, and I have heard and listened to your explanations, yours and your attorneys. Why? So what would help you with anger? What do you think? You've taken it a few times. Is there something, I read you kind of, I read some of your background and everything. And so I don't want to, we are live streaming and I don't want to get into it. So, but we want you to not have to go through that either. We don't want you in there. We don't want you, and this is not serving you in any way. It's also, of course, not serving your fiance, people who love you, children, and then of course, just the general public. So that, we want this to stop for everybody. Is there something, do you have any insight as to what might help? And I know that's a big question to ask. Have you taken programs in there, or is there something in there? Go ahead, please.
I mean, there's no programs in here, but I was doing good with the program out there when I was taking it. It was helping me. So, I cannot say that it hasn't. But, like I said, I'm not perfect. I just try to do what I have to do. It was just situations that occurred, But
If I may, as far as the program, this particular time, it's the nature of the disposition that precludes him because he's not being held on the $50 fine that was remitted. So he's not a sentenced prisoner. There's a parole remand. That's why he's being held. So he can't, the DOC is looking at it. He's not theirs at this point. He's paroled. And that's the problem. But he has engaged in treatment in the past when he was under DOC or out in the community. He was mandated to do it. He did it. Obviously, none of the violations are to do with him not complying. It's just the obedience to the law charge.
And
unfortunately, the disposition to the infraction, he's not DOC quote unquote property at this time. That's just unfortunate because even if he wanted to, he can't because
Thank you.
Doesn't have the correct status, I guess, in better language.
Thank you. I appreciate that. Okay. I see what you're saying. And then, of course, when you were when you were then being brought into custody, we have, you didn't receive a misconduct for it, but certainly there was an aggressive response to that as well. How has your behavior been in the facility since you've been in? How are you doing in there?
I'm fine. I'm fine.
Okay, so you haven't had any issues there? You've been able to manage things?
Say that again?
You've been able to manage your behavior and you've had no issues while you've been in there?
I mean, I've had a fighting ticket. I'm not gonna lie to you or whatever, but this is prison, and it's just protecting myself. You know what I mean? People found out that I was in here for those type of charges, and he wanted to talk junk to me, come in my face, and I just had to defend myself. But
Right. Let me look at my list of questions real quick. I appreciate very much your responses and having this conversation with me. So I make sure I'm not missing anything. Let's see, I think that might be it. Yeah, I think I'll pass it along to my colleagues, see if there's any other questions. Thank you for answering my questions again.
thank you.
Thank you, Board Member Rodriguez. Question?
Mr. Nelson, you can hear our concerns.
I can hear you.
You can hear our concerns.
Yes,
Right.
I understand.
You've had the opportunity to have treatment in the communities, and I know you said it was successful for you, but still there have been challenges in you being able to figure out how to manage your anger in certain kinds of stressful situations, and that concerns me. I'm sure it concerns us on the panel as well. The fighting ticket, was that the only ticket you got?
Intoxication.
When was that?
That was a couple months ago.
So I had it down as April 5th of this year. Is that correct?
Probably so. I'm sorry. Probably so. Yeah.
I mean, and I think that's the challenge I think that I'm facing anyway, in this particular situation. And I'm not sure where to go with it. I mean, it's.
I mean, everybody deserves a chance, So the only thing
I hear you. I hear you. I hear you on that, and I understand that. But just the fact that there's all of these outbursts from you in these situations, and that you haven't found a way to kind of be able to manage that and work through that. And even with, PCS doesn't even want you out at all.
If I may, based on the nature of the charges in the police report, as charged, based on that, I can understand them making that recommendation. But once again, I'm going to stand by my comments because I keep making them.
I heard you.
And I'm just not only here, Mr. Rodriguez, even at our hearing, we've had cases where there's been nollies and dismissals and findings are made. Do you see the disadvantage we're at? What's happening is if our clients this is not at Mr. Nelson. You guys, what you presented, I have no dispute with. The problem is if any of our clients, because they have a special label of a parole, there's police contact, there's no way for us to prevail. Anytime with a dismissed case, what else can I provide? They still make a finding. Nolly cases, they still make a finding. So we're in a tough position in our unit because if our clients, and I've been here from day one with our unit, all the attorneys in our office were fighting the same fight. If our client have police contact, I mean, what else can we do besides present a dismissal or a nollie and findings are made? The conduct meets the elements. I understand there's a different standard at the Board of Pardons and Parole. What we're looking for is some equity. Just because you're arrested doesn't mean, I've been saying that for 7 years at my hearing, just because you're arrested doesn't mean you did what the police claim you did. And if a charge is dismissed or nollied, because you're on parole, you have and I understand when you're on parole, you're subject to searches and seizures, cell phone, parole officers showing up at your door. We have no problems with that, but there has to be a middle ground where you start here and we end up here. Just because you're on parole, you can't be treated differently. I understand you have a different label, but at some point we have to find a middle ground.
Right. I think, if I may, I think his sentence goes till 2031, and right now the state has entrusted him with serving some of that in the community with strict supervision. And I think we are looking at the totality of behavior through discretionary parole and special parole for this sentence. And so the misconducts, the arrest in New York, and then the arrest now, and I do respect and understand that it's, policy differences that are significant.
Absolutely.
It can result in freedom loss, and so I respect and understand the argument you're making, the frustration that your division would have. We of course have to follow our policy, and there could be policy arguments made at higher levels than us.
I agree. I agree with that.
That's what we don't get paid that money, but
I agree.
but just so, because and I know your primary focus was on that reduction to an infraction, but I just wanted to just take it back a second.
And I also don't want,
It's the totality of the behavior during.
I also don't want to take away from the work that he has done.
Yes.
But there is a concern. I mean, that's kind of where we're at.
Yes, yes.
But we did see you were working.
Yeah.
Sorry,
no problems at all.
I don't want to take away from that. I don't want to take away from that. Nor do we want to see him here.
Are there any further questions?
I don't have.
Thank you.
Okay, so at this point, we are going to discuss where we are, and your participation in the hearing is concluded. We're going to deliberate and give you a decision.
Okay, thank you.
Like for me to step out of the room?
No, I mean, it's a public.
Is that what you usually do?
You're just, so your portion of the hearing is just over.
Okay.
Board Member Keith, your thoughts?
And this is a difficult scenario. Mr. Nelson, particularly in the beginning of his, it was a brief time before his release. He was released March 2021. His arrest in New York and confinement began September 2021. So only 6 months later was he then, began serving some time there, pre-sentence, pre-conviction. Then he was released back to Connecticut in January 2025. And then 2 months later had his first misconduct for the confrontation at the hospital. I certainly heard Mr. Nelson's argument, and this is an emotional, heated time when someone you love is at the hospital, particularly if it's because they're carrying their baby and there's challenges. And I don't mean to get into medical stuff, but since Mr. Nelson raised that, just reiterating what he had said. So I do understand that there were some misconducts and GPS things. Again, I said I'm not too much focused on that. But then there was one again in July. So this is now about 6 months after returning to Connecticut for punching a hole in his sister's drywall. And then, of course, the December arrest, which, I do appreciate the arguments and the fact that it was reduced to an infraction. And there were some, the hostility and the comments made in December. And then, so he has completed anger management recently and then had still some of these. And to Mr. Nelson's point, any behavior that we are used to, engaging in does not resolve itself immediately. I do understand that and respect that. And I do see he was working, and prior to this release, he didn't really have a big employment history. So he did that, he did well with that. He had the little things with GPS, but he did complete GPS monitoring before his arrest in New York, and he did that well. So, I mean, I had a home, so he was doing well to a degree, but these misconducts and the 2 arrests in such a short period of time on parole supervision are of course concerning. And so his sentence does go till 2031. I'm concerned that the anger and the inability to control it is still quite prevalent. The parole officers in the community expressed serious concern for public safety. And so, I am at this time in favor of a longer sanction.
But let's
One
not
year,
go
a year.
where we're there yet, because we
Okay.
want to have a
Okay.
discussion.
Well, I'm kind of in the same place as my colleague. And I guess I said earlier, I don't want to take away from what he's done. And I think he's, tried to work towards that, but there's still some issues that are really going on with him. And those concern me. The fact that he hasn't been able to find a way to work through his anger just really concerns me. And so I'm kind of in the same place.
So, and you're,
I don't want to discuss,
Yep. So, I just, I started the hearing, I wanted to lay out where we've been. And first and foremost, it's like, we have a felon with a gun and another gun and another gun. So number one, we can't go by the rules, by the laws. So it's a continued, I'm going to get out. And my concern is I'm going to get out and go get another gun. Right. So that's the first piece. Second piece is what's already laid out here, and that is a continuation of making decisions regarding others that have a disagreement with Mr. Nelson that immediately turn into things like threats, things like punching holes in walls, things like fights, things like that, and then a report, although not convicted in court, of a strangulation second, which is just a continued, movement path toward if I'm going to have a disagreement, I am not going to use what I learned in anger management. I'm going to continue to escalate this, right? And I know it's not an assault ticket, but then there's a fighting ticket while we're on a revocation. And then there's an intox ticket when we're on revocation, right? So I can't go by the rules as laid out for me to follow, right? So here, the question then comes to, what do I as a board member expect is going to happen if Mr. Nelson is released back into the community? Is he going to abide by the rules of parole, or excuse me, special parole? Or is he going to continue to do what what the track record shows that he's going to continue to do? And I get, there is a technicality about, not filing a certain piece of paper or document in court and resulting in certain things happening and stuff like that. I'm not concerned about documents in court. What I'm concerned about is a continued reaction to the things that are going on in Mr. Nelson's life.
Can I say something?
No, not at all.
Deliberating right now.
Okay.
So, he hasn't resolved anger issues. right? And he hasn't found a way to abide by the rules either, right? Continue to do that. And, and then, the truthfulness there is also concerning because it gets asked about an intox ticket. And it was a couple of months ago. No, it was a couple of weeks ago. So then it's like, for me, it's like, I hear what he's saying, but then it comes down to credibility. It's like that's the spot that I'm at. It's like, where are we? And so I appreciate that, he went out and he got a job at Turkey Hill and he started with anger management, behavioral health and stuff like that. But then he continued to make the decisions that put other people in a spot. So I'm in agreement that 4 months is not enough for me. And his end of special parole is 2031. Board Member Keys, I heard you say something about a total sanction of a year. And I can't argue with that. In fact, it's for me, it's something that's his ability to be on, or his being on special parole is important for when it comes to public safety. Because to go to the end here is not in the interest of public safety, right? And Mr. Nelson doesn't have to prove anything to us. He's got to prove things to himself, because this has got to stop. Or we're going to continue to, see Mr. Nelson on the other side of the screen. And I hope that he's got to the place where he's done with that. So if Board Member Keys, if you were suggesting a year, I would be supportive of that. And I'm not.
Well, I've always been, I went to be supportive. I do hope that Mr. Nelson continues in the path he's been at.
Yeah. He's on a, he had made a lot of progress compared to where he had been from everything we read. But
so,
and I'm sure he doesn't want to see himself in this situation anymore either.
So, I want to change also one of the conditions, well, not change, but I wanted to add to one of the conditions, because he's been through it, but I want him in anger management again in the community. I know that he has to do domestic violence, but in order for him to be successful out there, he needs to take what he needs to take to be supportive. And if things are under his skin when he's out there, he needs to talk about them in anger management and come up with ways to deal with, things that make him angry. And what are alternatives other than punching holes in the wall or, creating public disturbance, or anything like that. At this point, regarding George Nelson, 414045, move to increase the sanction to 1 year, and his special parole release date would be 12/23/26. Is that a Saturday or Sunday? with the following stipulations, to apply to his special pool. Behavioral management program for domestic violence, no contact with victims, SC, and HK. General no contact with ND. Mental health treatment. Is that mental health treatment or is that mental health treatment? With medication compliance, halfway house placement if necessary, and behavior management for anger management. Is there a second? Second. Those in favor signify by saying aye. Aye. No, the ayes have it. The special parole, release date to special parole is 12/23 with the stipulations as stated.
George, I'll set up a call with you tomorrow, kind of explain the process there.
Move the supplemental hearing for George Nelson, inmate number 414045.